Good morning. Welcome to the September 2018 open meeting of the Federal Communications Commission. Madam Secretary, would you please introduce our agenda this morning?
Thank you, Mr. Chairman. Good morning to you and good morning, Commissioners. For today's meeting, you will hear 7 items for your consideration and 1 presentation. First, you will consider a notice of proposed rulemaking addressing calls to 911 made from multi-line telephone systems pursuant to Carr's Law, the conveyance of dispatchable location with 911 calls as directed by Broadband Act, and the consolidation of the Commission's 911 rules. Second, you will hear a presentation on the recent results of the Connect America Fund Phase 2 auction, Auction 903. Third, you will consider a declaratory ruling and report and order that will clarify the scope and meaning of Sections 253 and 332C7 of the Communications Act, establish shot clocks for state and local approvals for the deployment of small wireless facilities, and provide guidance on streamlining state and local requirements on wireless infrastructure deployment. Fourth, you will consider an enforcement action. Fifth, you will consider an enforcement action. Sixth, you will consider a report and order that eliminates the Form 325 annual report of cable television systems filing requirement. Seventh, you will consider a report and order that will amend the Commission's rules to allow for use of auctions to assign certain toll-free numbers and takes other actions to modernize the administration and assignment of toll-free numbers. Eighth, you will consider action to facilitate the deployment of and harmonize the rules concerning 3 types of fixed satellite service earth stations authorized to transmit while in motion: earth stations on vessels, vehicle-mounted earth stations, and earth stations aboard aircraft. This is your agenda for today. Please note item 6 on the agenda as listed in the September 19th, 2018 Sunshine Notice, entitled Implementation of Section 621A1 of the Cable Communications Policy Act, as amended by the Cable Television Consumer Protection and Competition Act of 1992, was adopted by the Commission and deleted from today's agenda. The first item today will be presented by the Public Safety and Homeland Security Bureau and is entitled Implementing Carr's Law and Section 506 of Broadband Act, Inquiry Concerning 911 Access, Routing, and Location in Enterprise Communication Systems. Lisa Folks, Chief of the Bureau, will give the introduction.
Thank you, Madam Secretary. Ms. Folks, the floor is yours. And without stealing your thunder, however, I do want to recognize our 2 special guests at the table and welcome them here to the Commission and look forward to hearing what they have to say. Ms. Folks.
Good morning, Mr. Chairman, Mr. and Madam Commissioners. The public has a right to expect that when they dial 911, they will reach a 911 call center. The public also has the right to expect that accurate information about their location will be transmitted to the 911 call center so that they can be found quickly by first responders. This should happen regardless of whether you call 911 from home, work, a hotel, a college campus, or any other location. Unfortunately, this does not always happen. In a tragic incident in 2003, a woman named Carrie Renee Hunt was attacked and killed by her estranged husband in a motel room in Marshall, Texas. Ms. Hunt's daughter tried repeatedly to call 911 for help from the motel room phone, as she had been taught to do. But the call never went through because she did not know that the motel's phone system required dialing 9 for an outbound line before dialing 911. This tragic incident inspired Carr's Law, which the President signed into law earlier this year. Carr's Law requires implementation of direct 911 and notification capabilities in multi-line telephone systems, which serve environments such as businesses, hotels, and educational campuses. The President also signed a second 911-related statute this year, The Repack Airways Yielding Better Access for Users of Modern Services Act, or RABOMS Act, as it is commonly known. Section 506 of RABOMS Act requires the Commission to consider rules to ensure that a dispatchable location, for example, the caller's street address, floor, and room number, is conveyed with 911 calls, regardless of the technological platform used for the call. Today, we present a notice of proposed rulemaking that implements Carey's law and initiates the rulemaking on dispatchable location required by RABOMS Act. The notice also proposes to consolidate the Commission's 911 rules under a single rule part. Taken together, these proposed actions mark a significant step forward in the Commission's effort to ensure that the nation's 911 call system will always be there to provide help to people when they need it most. Before we present the item, I would like to welcome Hank Hunt, the father of Carrie Hunt, who has traveled to be with us today at the table. We will now hear Mr. Hunt's testimony.
Mr. Chairman, honorable commissioners, distinguished guests, I'm here in front of you today to once again talk about an issue that's dear to my heart. On December the 1st of 2013, my daughter Carrie was taken from her family and from us forever due to a simple configuration issue on a multi-line telephone system. 41 days after that, a gentleman by the name of Mark Fletcher sat down in your office, Mr. Chairman, and explained the issue to you and your staff. I believe that was on a Friday afternoon. 3 days later, you issued an inquiry to the top 10 hotel chains of the United States to assess the issue. You published those results of that inquiry a few months later and said that they were completely unacceptable. And I got to tell you, I certainly agreed with you. You took immediate action, and together we convinced the MLTS industry and the Hotel and Lodging Association to correct this issue, and they did. The FCC even corrected their own MLTS after a blog by Commissioner O'Reilly noted that 911 didn't work in this very building. Fortunately, it now does. 1,539 days after my daughter's death, on February the 16th of this year, I stood with you, Mr. Chairman, in the Oval Office of the White House as President Trump signed Carey's law into the law of the land. This brought a huge amount of awareness to the issues to schools, commercial businesses, and any place else that uses a multi-line telephone system. It's now 1,761 days since Carey died. And I stand here before you to talk about adding teeth to a law with provisions that were in the original drafts. Mr. Chairman, honorable commissioners, I'm tired of counting days. I am, however, anxious to see the days ahead count. We need to fix this problem once and for all. There are so many aspects to 911 that someone like myself always assume that if you pick up a phone, you can call 911 and receive help. So I have to wonder what makes it so complicated. Is it technology? I don't think so. Technology is great. Is the process of dialing? No, it's real simple, 9 and a 1 and a 1. Is it the cost? Not the cost. Actually, 911 could be free to the public. And anyone that argues with that has a bottom line they're probably nursing like a little baby. There are, however, suggestions to make MLTS extensions location-specific, which would add undue cost, in my opinion, and would not benefit first responders. As a former first responder, I know firsthand the value of on-site information. I remember responding to a structure fire in which we were deploying hoses and charging the monitor. The owner of the property arrived and informed us of 31 propane tanks in the garage. That quickly changed our attack procedures. We immediately protected the garage. Without that information from the on-site, from the gentleman on site there, we would never have known, and might have turned out a lot worse than it was. Children as well as adults know 911. It's taught, it's ingrained from a childhood. It's on our police cars, fire trucks, ambulances. It's an institution within itself that has saved countless lives. I would hate to make things difficult and more expensive when it isn't needed. We created 911 to save lives, and lives it has saved. After decades of technological advances, 911 has somehow lagged behind. Today, we have an opportunity to bring dignity and common sense to a system the public depends on. I have full faith that the tenets of Carr's Law are meaningful and will remain relevant. Whatever tweaks that may come, I sincerely hope to see the spirit of the law survive by being a workable solution to a simple problem at little to no cost. To sum this up, this proceeding has a lot of important content, but it also contains some language that refers to yesterday's technology trying to correct tomorrow's problem. We need to build for the future. We need to make sure we can get this right. We may not have a chance to come back later. This directly impacts people's lives. We need to make sure that this is an affordable solution that gets implemented. Carr's Law is about getting the right information to the right people at the right time. We need to ensure first responders have access to current and actionable information when they arrive on the scene. The technology exists to do this today. Any building in D.C., you're going to end up looking at a panel, a fire alarm panel as you walk in the door. Just inside, most MLTS systems are intelligent enough to do the same thing with a 911 call. I want to thank you for inviting me here today. I'm honored to be able to make any kind of contribution when making 911 safe, especially for children. And I thank you.
Thank you, Mr. Hunt. With me at the table today from the Public Safety and Homeland Security Bureau are David Firth, Deputy Bureau Chief, John Evanoff, Deputy Chief of the Policy and Licensing Division, Austin Rendazzo, Attorney Advisor, and Brenda Boykin, Attorney Advisor in the Policy and Licensing Division. I would like to thank the division and other Bureau staff for their always excellent work, as well as other bureaus and offices that contributed to this item. Ms. Boykin will present the item.
Thank you, Chief Folks. Good morning, Chairman Pai and Commissioners. Today's notice implements two recently enacted laws to improve the 911 system, Carr's Law and Section 506 of Ray Baum's Act. As Chief Folks noted, Carr's Law requires direct 911 dialing and notification capabilities in multi-line telephone systems, which are typically found in office buildings, campuses, and hotels. The notice proposes implementing regulations to provide clarity and specificity regarding the obligations that Carr's Law places on covered entities. Under the proposed rules, multi-line telephone system manufacturers and vendors must pre-configure these systems to support direct dialing of 911. That is, to enable the user to dial 911 without having to dial any prefix or access code, such as the number 9. In addition, installers, managers, and operators of multi-line telephone systems must ensure that the systems support 911 direct dialing. The notice also proposes to implement the notification requirement under Carr's Law. When a 911 call is placed on a multi-line telephone system, the notice proposes that the system must be configured to provide a separate notification, either to an on-site location at the facility where the system is installed, or to an off-site person or organization, and this is to facilitate building entry by first responders. Consistent with the 2-year timetable established by Carr's Law, the notice proposes February 16, 2020, 2 years after the law's enactment, as the compliance date for these new rules. Section 506 of Ray Baum's Act requires the Commission to consider rules to ensure that dispatchable location is conveyed with 911 calls, regardless of the technological platform used. Dispatchable location includes the street address of the caller, as well as additional information such as room number and floor number that is necessary to identify the caller's location. Consistent with the Act's all platforms approach, the notice proposes dispatchable location requirements for multi-line telephone systems, fixed telephony providers, interconnected voice over Internet protocol or VoIP providers, and telecommunications relay services providers. The notice also considers whether dispatchable location requirements should be extended to other communication services that currently are not covered by the 911 rules, but that can access 911. However, the notice does not propose to change existing dispatchable location requirements already applicable to commercial mobile radio services. Finally, the notice proposes to consolidate the Commission's 911 rules into a single rule part. Historically, the Commission has implemented 911 rules on a service-by-service basis. As a result, these rules currently reside in various parts of Title 47 of the Code of Federal Regulations. Consolidating the 911 rules into a single rule part, as proposed, will further the goal of recognizing that all the components of 911 function as part of a single system. In addition, consolidation will make it easier for service providers, emergency management officials, and other stakeholders to determine the 911 requirements that apply to them. The Bureau recommends adoption of this notice and requests editorial privileges for technical and conforming edits. Thank you.
Thank you, Ms. Boykin, for your presentation, and again, Mr. Hunt, for that very compelling, those very compelling words you offered. I will now turn to comments from the bench, beginning with Commissioner O'Reilly.
You sure you want to go first? Oh, okay. Mr. Hunt, I'm truly sorry for the events that led you to be here today and the experiences your family had to go through. Unbelievable. As I've repeatedly said, when Congress provides the FCC with direction, I will faithfully implement their will. The vast majority of today's items seeks comment on various provisions of Carr's Law Act of 2017 and a section of Raybom's Act. For this reason, I generally support this notice. I do have some concerns that some portions stretch the law and maybe not intended. For instance, the item contemplates potential new labels and sticker requirements. And for those of us that were around in the early 2000s, we remember the last attempt at these sticker requirements on VoIP and how beneficial that was. So I look forward to discussing all of these relevant issues with interested parties in the coming months as we get to order. And I hope the Commission will implement the statute as intended and will look to keep burdens to minimal as possible. I'll submit my full statement for the record. Thank you.
Thank you, Commissioner O'Reilly. Commissioner Carr.
Thanks. Hank Fletch, it's good to see you again, and thank you for your presentation this morning and for your uncommon resolve in the face of tragedy. I also want to recognize the strength of your wife, DJ, who is hopefully keeping an eye on this back in Texas. You both worked tirelessly to educate the public on the need for direct dial 911. And what's more, you made it happen. You traveled the country advocating for the enactment of Carr's Law in states across the U.S. And in this item, one theme stands out to me. It's that of new technologies helping to bring old ones into the modern era. It was there from the beginning. For example, if I recall correctly, then Commissioner Pai first learned of Hank and DJ's family and their story from a tweet sent by Fletch. And after he looked into the issue, Commissioner Pai discovered that phone systems in many hotels, schools, and other large buildings, even here in the FCC, required callers to press 9 before dialing 911. And recognizing the seriousness of this issue, Commissioner Pai followed your lead, and he worked tirelessly in search of a solution. He worked with hotels around the country, MLTS manufacturers, to identify the problem. He encouraged these entities to take voluntary steps to ensure direct access on all MLTS. He also advocated for a default configuration to enable direct dialing 911 and pushed with Commissioner O'Reilly, as we've heard, to successfully change the FCC's own phone system. And he championed legislation at both the state and federal level that changed the status quo. And speaking of legislation, thanks to the efforts of several members of Congress, including Senators Fisher and Klobuchar and Congressman Gomer, Carr's Law became the law of the land nationwide when President Trump signed it this past February. I want to recognize Jamie Suskin and my staff who had the chance to work on that legislation during her time with Senator Fisher in the Senate. And now we're here today to begin the final steps of implementing it. So I'm very glad to support this notice, which will take much needed steps to ensure that when any child does exactly what their parents teach them to do in an emergency, to dial 911, that the call goes through. So I'm grateful, Hank, to you and your family for for your courage, your leadership, and glad to cast a vote in favor of today's decision. And I want to thank the Public Safety Bureau for their work on this. Thanks.
Thank you, Commissioner Carr. Commissioner Rosenworcel.
Mr. Hunt, thank you for your testimony, but more importantly, thank you for your tenacity. As a result of your efforts, we have a new law on the books. It's an extraordinary way to honor your daughter, but also to make all of us and all of our children safer. So thank you for that. Earlier this month, I visited the Los Angeles Metropolitan Dispatch 911 call center with Congresswoman Norma Torres. Now, I've been to dozens of public safety answering points in every part of the country, from Alaska to Alabama, Vermont to Virginia, and many more places in between. But this visit was unique. That's because Congresswoman Torres used to work there as a 911 operator. In fact, she's the only member of Congress who can claim to have served in this role. In short, she knows a thing or two about public safety. She introduced me that day to other 911 operators who are quiet heroes. With steely calm, they take in call after call from people on the worst day of their lives. They gather the facts from callers in trying circumstances and skillfully dispatch our first responders. It's important to remember that before any blue and red light flashes, whistle at the fire station blows, pager rings, or air horn blares, on the front line of public safety in the United States are 911 operators. We need to provide them with the tools they need to do their jobs. Because when our 911 operators have the right tools, we are all safer. And for me, that's what today's rulemaking is all about. It does two essential things. First, it seeks comment on implementation of Carr's law, which requires direct 911 dialing and on-site notification capabilities in multi-line telephone systems. Second, it seeks comment on Section 506 of Ray Baum's Act, which requires this agency to complete a proceeding to ensure that dispatchable location is conveyed with 911 calls, regardless of the technology that a caller uses to make the call. This rulemaking has my full support, and that's because at the end of the day, this is simple. When you pick up the phone to call 911, it should work. When one of tens of thousands of 911 call operators on the other end of the call answers, they should receive the location information they need to send help. But as we move forward, I hope we keep another simple concept in mind, and that's a deadline. When the FCC completes its work in this proceeding, I want us to be able to say by 2020, 911 callers across the country can expect that whenever, wherever, and however they call for help, first responders can find them. Now let's get to it.
Thank you, Commissioner. For nearly 5 years, I have had the honor of working alongside Hank Hunt, as well as his troublemaking companion, Mark Fletcher. Hank has been a model of courage and an inspiration to me. From my first talk with him in late 2013, I believe it was, just a few weeks after Carrie was murdered, to our most recent in-person conversation when, as Hank described it, we were in the Oval Office watching President Trump sign legislation named after his late daughter. Hank has described Carrie's tragic fate on that day 5 years ago, and since that day, out of grief and a desire to make a change, Hank has worked tirelessly to tell Carrie's story. I've seen him at work for a while, so I wasn't surprised that he has been able to get results. As I said a few years ago, he's a great example of that old saying that one man with courage makes a majority. One of the most remarkable results came earlier this year. In February, as Hank described it, Congress passed the Carr's Law Act of 2017, which requires multi-line telephone systems, or MLTS, such as the hotel phone used by Carrie's daughter, to permit users to directly dial 911 without having to dial any access code, prefix, or the like. And on February 16th of this year, which happened to be the 50th anniversary of the very first 911 call made in the United States, Hank and I stood together in the Oval Office as President Trump signed the law. It is hard to describe what it was like watching Hank and his now 13-year-old granddaughter in that moment. I wish I had the poise that each of you did. Well, now it's the FCC's turn to act for Carrie. And so in this notice, we propose rules to implement Carrie's law so that when Americans dial 911 from multi-line telephone systems, which are commonly used in office buildings and hotels, as well as on campuses, they can reach emergency services. But sometimes being able to reach emergency services isn't enough. For example, if you're calling 911 from a large office building, it is important that first responders know that you are in the building, where you are in the building, so that they can find you. That's why we're also proposing to mandate that 911 calls from MLTS include a dispatchable location, and that this requirement take effect at the same time as compliance that is required under Carrie's law. And we are also seeking comment on the feasibility of requiring dispatchable location for 911 calls from other technological platforms, as required by the Ray-Bombs Act. Finally, as Ms. Boykin observed, as a matter of good government, we are proposing to consolidate the Commission's existing 911 rules in one place. Today, those rules are scattered throughout Title 47 of the Code of Federal Regulations. A lot of details in this item, but the conclusion is pretty simple. I just want to thank Hank for your advocacy and for your friendship. And I know it has been a very long road for you. But the fact that the FCC is implementing a new law named after your daughter is a testament to your dedication and your persistence. And it proves that Carrie did not die in vain. I also want to thank those in Congress who sponsored Carrie's law, as well as those who sponsored Ray-Bombs Act. I also want to recognize my former public safety advisor who helped mobilize our efforts in 2013, 2014, and 2015 to tackle that problem. I hear he made something of himself. And many thanks to the FCC staff who helped preserve Carrie's memory by working on this important item, from the Public Safety and Homeland Security Bureau, the Consumer and Governmental Affairs Bureau, the Enforcement Bureau, the International Bureau, the Office of Communications Business Opportunities, the Office of Engineering and Technology, the Office of General Counsel, the Office of the Secretary, the Office of Strategic Planning and Policy Analysis, the Wireline Competition Bureau, and the Wireless Telecommunications Bureau. As you can tell, Hank, we pulled out all the stops and made it a cross-agency effort to make sure that Carrie's memory was honored in our implementation of her legislation. With that, we will proceed to a vote on the item. Commissioner O'Reilly.
Aye.
Commissioner Carr?
Aye.
Commissioner Rosenworcel?
Aye.
The chair votes aye as well. The item is adopted with editorial privileges granted as requested. Thank you once again to all of you for being here. Madam Secretary, could you please announce the next item on today's agenda?
Mr. Chairman and Commissioners, next you will hear a presentation on results of the Connect America Fund Phase 2 auction presented by the Rural Broadband Auctions Task Force. Chelsea Fallon, Director of the task force, will give the introduction.
Ms. Fallon, if you and your team are ready, the floor is yours.
Thank you. Good morning, Mr. Chairman and Commissioners. I am pleased to present to you today an overview of the results of the Connect America Fund Phase 2 auction. Because of this auction, over 700,000 homes and small businesses in rural and remote areas of the country will gain access to broadband for the first time, and at faster speeds and a lower cost to ratepayers than would have occurred through more traditional means of allocating high-cost universal service support. The innovative auction design enabled a variety of different companies to compete for support in a multiple-round reverse auction and ultimately allocated $1.49 billion in support over 10 years to over 100 winning bidders. The Rural Broadband Auctions Task Force would like to acknowledge and thank the team from the Wireline Competition Bureau and Wireless Telecommunications Bureau who made this auction a reality. As well as staff from the International Bureau and the offices of the Managing Director, General Counsel, Legislative Affairs, Media Relations, and Strategic Planning and Policy for their support. Everyone who contributed to the auction is listed on this slide. And with me at the table are Kirk Berge, Deputy Director of the Rural Broadband Auctions Task Force, Nathan Egan, Chief of Staff of the Task Force, Don Stockdale, Chief of the Wireless Telecommunications Bureau, Chris Monteith, Chief of the Wireline Competition Bureau, and Shabnam Javid, Program Manager in the Auctions and Spectrum Access Division of the Wireless Telecommunications Bureau. And Shabnam will present the report.
Thank you, Chelsea. Good morning, Mr. Chairman and Commissioners. The Connect America Fund Phase 2 auction was the first multiple-round reverse auction to allocate ongoing, high-cost universal service support for fixed broadband service. Just over 974,000 locations across the United States were eligible for support in this auction. These locations are in areas where price cap carriers did not accept support offered through a cost model, areas deemed to be extremely high cost by that cost model, as well as certain other areas. In addition, these areas are not served by any unsubsidized competitor offering both voice and broadband at speeds of 10 megabits per second down and 1 megabit per second up or higher. Absent universal service funding, broadband deployment in these areas would not be economically feasible. The aggregate reserve price for all of the areas available in the auction, as determined by the cost model, was $6.1 billion over 10 years. The total budget for the auction, established by the Commission, was $1.98 billion for 10 years. Hence, the Commission used an auction mechanism and competition among bidders to efficiently allocate the limited budget and determine which areas would be served and for how much. Each bid in the auction represented a commitment by a bidder to deploy fixed broadband and voice services in a particular geographic area in return for a certain amount of support. The auction used a weighting system so that the amount of support associated with a bid depended on the speed, latency, and usage level associated with the broadband service. There were 4 performance tiers in the auction, each with a different minimum download and upload speed and usage allowance, and 2 latency tiers, 1 high latency and 1 low latency. Higher support amounts were awarded for higher speeds, lower latency services. Bids started high and went down in each round of the auction. Bids were considered simultaneously so that bidders proposing to meet one set of performance standards competed directly against bidders proposing to meet another standard. The weighted tiers encouraged participation from a variety of different companies using a range of technologies. 220 bidders were eligible to participate in the auction, and of those, 173 bidders placed bids once the auction began. Bidding in the Phase 2 auction started on July 24, 2018, and concluded on August 21, 2018. The auction allocated $1.49 billion in support over 10 years to bidders committing to offer fixed voice and broadband services to over 713,000 locations across 45 states. More than 99% of these locations should receive broadband at speeds of 25 megabits per second down and 3 megabits per second up or higher, which is more than twice the minimum standard for recipients of Phase 2 model-based support. The aggregate reserve price associated with the areas that won support was approximately $5 billion over 10 years, but because of price competition in the auction, they will now be served at a much lower cost to ratepayers. Inter-area competition, in which bidders competed for the total funds available in the auction, brought the price to serve these areas down to $1.98 billion. Then, once the budget cleared, intra-area competition brought the price down further to $1.49 billion. There were 103 winning bidders in the auction. The winning bidders include a range of different types of companies, such as wireless internet service providers, electric cooperatives, cable operators, local exchange carriers, and a satellite company. This slide shows the speed tiers associated with the winning bids in the auction. The lowest speed tier that bidders could commit to providing was 10 megabits per second down and 1 megabit per second up. However, 99.75% of the locations which won support in the auction should receive service that is more than twice as fast, since the winning bidders committed to offering broadband service at 25 megabits per second down and 3 megabits per second up or higher. 53% of locations that won support should receive broadband service with download speeds of at least 100 megabits per second, and 19% should receive gigabit service. This map depicts the areas of the country that received winning bids in the auction. These are the areas that winning bidders have committed serving over the next 6 years. The auction encouraged innovation and deployment of robust services by giving winning bidders the flexibility to use any technology or multiple technologies to meet the FCC's build-out and performance standards for fixed service. Winning bidders in the auction must file long-form applications by October 15th in order to become authorized to receive support. Once they have been authorized to receive support, they must build out their network and begin offering service to at least 40% of the locations won in a state within 3 years. They must serve an additional 20% of the locations each subsequent year until reaching 100% of locations by the end of the 6th year. Data on the locations served must be filed with the Universal Service Administrative Company, or USAC, and penalties can be imposed for failure to reach the build-out milestones. In addition, support recipients must comply with requirements adopted earlier this year for measuring and reporting on the performance of their networks. We hope the success and lessons learned from the Connect America Fund Phase 2 auction will help inform policymaking for future commission auctions of universal service support, including the Mobility Fund Phase 2 auction, the Remote Areas Fund, and Phase 3 of the Connect America Fund. Thank you.
Thank you for that excellent presentation to Ms. Fallon as well. We'll turn to any comments from the bench from Commissioner O'Reilly.
Sure. I want to applaud the staff and the chairman for the outcome of the auction. It was a multi-year effort. I remember having to drag former chairman Tom Wheeler to the right direction on a number of things when his team was trying to take him in a bad direction. So I'm glad the outcome. But I did have some questions, though. I'm trying to figure, like, if I look at this, the numbers that you presented, it was, it had 713,000 locations at $1.49 billion. It's about $2,000 a location. We have, give or take, 12 million individuals who don't have service after this effect. I mean, what's the scope? What does that leave us for a scope of the RAF? If it's $2,000 a location, how much money are we going to need for the remaining 12 million, even if locations are only, a fraction of the population? It suggests to me a $5 to $7 billion need for the RAF. Is that what the contemplating in the task force?
I think that's something we'll definitely have to look at going forward, is how to serve the remaining locations that do not have broadband, and there are definitely a number of locations that will get service as a result of this, and areas that were unassigned, unwon in this auction, and would go into the RAF inventory. And the Commission has made some decisions related to the RAF, but additional decisions need to be made, and we'll definitely have to.
But is it fair
look
to
at
say
that.
we only have, of the money not spent of the $2 billion, we have about $500 million left?
And
So if
that's-
I'm thinking of a $7 billion RAF necessity based, if we just did, stretching this math out, that's pretty big shortfall, right?
Well, I think we'll have to look at the best way to determine the amount of support that's needed and the best way to what the best use of the funds that were not spent in this auction going forward, and develop some proposals on that.
Do we have a time
the
frame on how
commission.
soon we can do some of that math?
We'll look at that and do that as soon as
I
possible.
look forward to working with you on that. I
All
thank
right,
the chair.
Thank you.
Commissioner Carr?
Thank you for the presentation and for your work on this. Thanks.
Commissioner Rosenworcel?
Likewise, I want to thank you for the work on this. I know that it took many months, many bureaus, and many late hours. But what we have is, in many ways, a new model for universal service policy. So I want to thank you for your efforts, not just now, but going forward as we assess how this new model works.
I want to echo Commissioner Rosenworcel's words and simply add that the details of the presentation were obviously quite compelling, and they painted a picture of a very sophisticated model that distributed funding efficiently. And we heard a lot of terms that I think the average person may not grasp if they don't labor within these walls: multiple round reverse auction, latency tiers, speed tiers, long form applications, and the aggregate reserve prices. What this means is digital opportunity for thousands or hundreds of thousands more people. This is why it matters. A few weeks ago, I was in Westfield, Massachusetts, a small town in western Massachusetts that is essentially a hub for even smaller towns in western Massachusetts. And I visited Westfield Gas and Electric, one of the utilities that did win funding in the Connect America Fund auction. And when you stand there and you see these 3-mile-long spools of fiber ready to be deployed, when you meet with the local leaders from neighboring towns, some of which are just several hundred people, and you see what it means to them to finally have the promise of having a broadband connection in their town so that a local businesswoman can start a business, kids can get educated, telemedicine is a reality, and the like, you see why this work is so important. However detailed and arcane these proceedings might be on the page, they make a real difference in the lives of Americans. And to hear from Doug McNally, a local leader, who said, and I quote, "This is a lifesaver for the town of Windsor." 900 people. Those are 900 people who are on the wrong side of the digital divide who, because of your efforts, are going to be on the right side. So I simply want to say thank you for the Herculean efforts that went into this. You saw from the listing of the staff how many people were involved in this effort and from how many bureaus and offices. Much more work to come, of course, and the work is only getting started. It's not yet done, but nonetheless, I think you have put the FCC on the map as the lead agency in helping to close the digital divide. And for that, I and thousands, if not millions of Americans across the country are deeply grateful to you. Thank you, Ms. Fallon, for your leadership of the Rural Broadband Auctions Task Force, and to all of you for being here this morning. With that, we will move to the next item on today's agenda. Madam Secretary, if you would.
Mr. Chairman and Commissioners, the third item on your agenda will be presented by the Wireless Telecommunications Bureau and is entitled Accelerating Wireless Broadband Deployment by Removing Barriers to Infrastructure Investment, Accelerating Wireline Broadband Deployment. Donald Stockdale, Chief of the Bureau, will give the introduction.
Thank you, Madam Secretary. Mr. Stockdale, if your team is ready, the floor is yours.
Good morning, Mr. Chairman, Commissioners. I am pleased to present a declaratory ruling and third report in order in the Commission's Accelerating Wireless Broadband Deployment by Removing Barriers to Infrastructure Investment proceeding. I'm joined at the table today by Suzanne Tétrault, Garnet Hanley, Jimeng Shang, Jonathan Lecter, and Daryl Pay. In addition to the staff at the table, I would like to thank everyone listed on the slide for their work on the item. Daryl will now present the item.
Thanks, Don. Good morning, Mr. Chairman and Commissioners. We present to you today a declaratory ruling and third report in order that would reduce state and local regulatory impediments to the deployment of 5G and other advanced wireless services. The declaratory ruling would reaffirm the so-called California Payphone Standard for interpreting Sections 253 and 332 of the Communications Act. Under that standard, a state or local requirement constitutes an effective prohibition violative of Sections 253 and 332 if it materially limits or inhibits the ability of any competitor or potential competitor to compete in a fair and balanced legal and regulatory environment. Applying this standard, the declaratory ruling would clarify that state and local fees and other charges associated with the deployment of wireless infrastructure are consistent with Sections 253 and 332 only if they are a reasonable approximation of the state or local government's costs, the costs factored into the fees are objectively reasonable, and the fees are no higher than the fees charged to similarly situated competitors in similar situations. The declaratory ruling also would provide guidance on the applications of this standard to other state and local restrictions, including statics and undergrounding requirements. The third reporting order would establish two new Section 332 shot clocks for state and local review of small wireless facilities applications. Specifically, it would establish a 60-day shot clock for co-location of small wireless facilities and a 90-day shot clock for the construction of new small wireless facilities. Due to the shortened shot clock timeframes for small wireless facilities, local authorities would be able to restart these shot clocks for initial applications if they notify the applicant of material deficiencies in the application within 10 days. The reporting order would also codify the existing shot clocks that the Commission established in 2009 and would establish a new remedy available to applicants when citing authorities fail to act within the new Section 332 shot clocks. The third reporting order would conclude that the shot clocks apply to all authorizations necessary for the deployment of personal wireless service facilities, and the shot clock for batched applications is the same as if the applications had been submitted individually. Collectively, the measures in this declaratory ruling and third reporting order would eliminate regulatory barriers that unlawfully inhibit the deployment of infrastructure necessary to support advanced wireless services, and would establish procedures that would expedite the deployment of wireless infrastructure across the nation. The Wireless Telecommunications Bureau recommends adoption of this item and requests editorial privileges to make technical or conforming edits. Thank you.
Thank you for that presentation. If I might ask, is this your first time presenting at a commission meeting?
It's my second, Chairman.
Second. Well, very well done. Thank you for the presentation. Now turn to comments from the bench, beginning with Commissioner O'Reilly.
I thank the chair. I enthusiastically support the intent of today's item and the vast majority of its content, as it will lower the barriers that some localities place to infrastructure siting. By tackling absorbent fees, ridiculous practices, and prolonged delays, we are taking the necessary steps to expedite deployment and make it more cost-efficient. Collectively, these provisions will help facilitate the deployment of 5G and enable providers to expand services throughout our nation, with ultimate beneficiaries being the American people. Well, this is a tremendous step in the right direction. There are some things that could have been done to improve the situation further. For instance, the agreement reached by all parties in the 1996 Telecom Act, which I was there, was that states and localities would have no role over radio frequency emission issues, could not regulate based on aesthetics of towers and antennas, and were prohibited from imposing any moratoriums on processing wireless siting applications. State and localities did not honor this agreement, and the courts have sadly enabled their efforts via harmful and wrongly decided cases. Accordingly, I would have preferred that the aesthetics-related provisions in the item be deleted, but I'll have to swallow it, recognizing that I can't get the rest without it. At the very least, I do appreciate that at my request, it was clarified that the aesthetic requirements, which must be published in advance, must be objective. I'm also concerned that by setting application and reoccurring fees that are presumed to be reasonable, the Commission is inviting localities to adopt these rates, even if they're not cost-based. Providers should be explicitly provided the right to challenge these rates if they believe they are not cost-based. Further, I think there should be a process and standards in place if a locality decides it needs more time to review batched applications. Objective criteria are needed regarding what is considered exceptional circumstances or exceptional cases, warranting a longer review period for batch processing when localities need to inform the applicant that they need more time, how this notification will occur, and how much time they will get. Without further clarity, I fear we may be creating unnecessary loopholes, resulting in further delay. Finally, I would have liked this item to be broader and covering the remaining infrastructure items in the record. First, the Commission's new interpretation of Section 253 and 332 applies to small cells. Well, our focus has been on these newer technologies, there needs to be a recognition that macro towers will continue to play a role in wireless networks. One tower provider states that macro sites will continue to be a central component of wireless infrastructure because 80% of the population lives in suburban or rural areas where macro sites are the most efficient way to transmit wireless signals. Further, many of the interpretations in today's item apply not only to macro towers, but also to other telecommunications services, including those provided by traditional wireline carriers and potential cable companies. Second, the Commission needs to close loopholes in Section 6409 that some localities have been exploiting. While these rules pertaining to the modification of existing structures are clear, some localities are trying to undermine Congress's intent and our actions. I appreciate the Chairman's firm commitment to my request that an additional item to address these and many other items will be done in the near future. Third, there needs to be an effort to harmonize our rules regarding compound expansion. And while we're at it, the Commission should also harmonize its shot clocks and remedies. Lastly, the Commission must also finish the Twilight Tower program comment. It is time to bring this embarrassment, which started in 2001, to an end. Not only do I thank the Chairman for agreeing to additional infrastructure items, I also thank him and Commissioner Carr for implementing several of my other edits to the item today, and I thank them for their work. With that, I'm going to approve.
Thank you, Commissioner O'Reilly. Commissioner Carr.
Thanks. The United States is on the cusp of a major upgrade in wireless to 5G. The Wall Street Journal has called it transformative from a technological and economic perspective. And they're right. Winning the global race to 5G, seeing this new platform deployed in the U.S. first, is about economic leadership for the next decade. Those are the stakes. And here's how we know it. Think back 10 years ago when we were on the cusp of upgrading from 3G to 4G. Think about the largest stocks and some of the biggest drivers of our economy back then. It was big banks and big oil. Fast forward to today, US-based technology companies from Facebook, Apple, Amazon, Netflix, and Google, down to the latest startup, have transformed our economy and our lives. Think about your own life. A decade ago, catching a ride across town involved calling a phone number, waiting 20 minutes for a cab to arrive, and paying rates that were inaccessible to many people. Today, we have Lyft, Uber, Via, and other options. A decade ago, sending money meant going to a brick and mortar bank, standing in that rope line, getting frustrated when that pen leashed to the table was out of ink again, and ultimately conducting your transaction in person with a teller. Now with Square, Venmo, and other apps, you can send money or deposit checks from anywhere 24 hours a day. A decade ago, taking a road trip across the country meant walking into your local AAA office, telling them the stops along your way, always including Parsons, of course, and waiting for them to print out on paper a triptych booklet filled with maps that you would unfold as you drove down the highway. Now with Google Maps and other apps, you get real-time updates and directions right on your smartphone. American companies led the way in developing these 4G innovations. But it's not by chance or luck that the U.S. is the world's tech and innovation hub. We have the strongest wireless economy in the world because we won the race to 4G. No country had faster 4G deployment and more investment than we did. Winning the race to 4G added $100 billion to our GDP. It led to $125 billion in revenue for U.S. companies that could have gone abroad. It grew wireless jobs in the U.S. by 84%. And our world-leading 4G networks now support today's $950 billion app economy. That history should remind policymakers at all levels of government exactly what is at stake. 5G is about our leadership for the next decade. And being first matters. It determines whether capital will flow here, whether innovators will start their new businesses here, and whether the economy that benefits is the one here. Or as Deloitte put it, first adopter countries could sustain more than a decade of competitive advantage. We're not the only country that wants to be first to 5G. One of our biggest competitors is China. They view 5G as a chance to flip the script. They want to lead the tech sector for the next decade. And they are moving aggressively to deploy the infrastructure needed for 5G. Since 2015, China has deployed 350,000 cell sites. We've built fewer than 30,000. Every day, China is deploying 460 cell sites. That's 12 times our pace. We have to be honest about this infrastructure challenge and show the courage to act. The time for empty statements about carrots and sticks is over. We need a concrete plan to close the gap with China and win the race to 5G. We take this challenge seriously at the FCC, and we're getting the government out of the way so that the private sector can invest and compete. In March, we held that small cells should be treated differently than large 200-foot towers, and we're already seeing results. That decision cut $1.5 billion in red tape, and one provider reports that it's now clearing small cells for construction at 6 times the pace as before that decision. So we're making progress in closing the infrastructure gap with China, but hurdles remain. We've heard from dozens of mayors, local officials, state lawmakers who get what 5G means. They understand the economic opportunity that comes with it. But they worry that the billions in investment needed to deploy these networks will be consumed by the high fees and long delays imposed by big, must-serve cities. They worry that without federal action, they may not see 5G. And I'd like to read from a few of the many comments I received over the last few months. Dwayne Ankney is a retired coal miner from Montana, a member of the state legislature and chair of its Energy and Telecom Committee. He writes, "Where I see the problem is the most of the investment capital is spent in larger urban areas. This is primarily due to the high regulatory cost and the cost recovery that can be made in those areas. This leaves the rural areas out." Mary Wiseman, an Iowa commissioner, writes, "With 99 counties in Iowa, we understand the need to streamline the network build-out process so it's not just the big cities that get 5G, but also our small towns. If companies are tied up with delays and high fees, it's going to take that much longer for each and every Iowan to see the next generation of connectivity." Ashton Hayward, the mayor of Pensacola, Florida, writes, "Excessive and arbitrary fees result in nothing more than telecom providers being required to spend limited investment dollars on fees as opposed to spending those limited resources on the type of high-speed infrastructure that is important to our community." And the entire Board of Commissioners from a more rural area in Michigan writes, "Smaller communities such as those located in St. Clair County would benefit by having the FCC reduce the costly and unnecessary fees that some larger communities place on small cells as a condition of deployment." These fees, wholly disproportionate to any cost, put communities like ours at an unfair disadvantage. By making small cell deployment less expensive, the FCC will send a clear message that all communities, regardless of size, should share in the benefits of this crucial new technology. They're right. When I think about success, when I think about winning the race to 5G, the finish line is not the moment we see next-gen deployments in New York or San Francisco. Success can only be achieved when all Americans, no matter where they live, have a fair shot at fast, affordable broadband. So today, we build on the smart infrastructure policies championed by local leaders. We ensure that no city is subsidizing 5G. We prevent excessive fees that would threaten 5G deployment, and we update our shot clocks to account for new small cell deployments. Now, on this last point, I want to thank Commissioner Rosenworcel for improving the new shot clocks with edits that protect municipalities from providers that would submit incomplete applications and provide localities with more time to adjust their operations to these new shot clocks. Her ideas improve this portion of the item. More broadly, our decision today has benefited from the diverse views expressed by a range of stakeholders. On the local government side, I met with mayors, city planners, and officials in their home communities and learned from their perspectives. They pushed back on the proposed deemed granted remedy, on regulations governing rents that they could charge for property outside of rights of way, and on limits to reasonable aesthetic reviews. They reminded me that they are the ones that get pulled aside at the grocery store when an unsightly small cell goes up. Their views carried the day on all of those points. And our approach respects the compromise reached in state legislatures around the country by not preempting nearly any of the provisions in the 20 state-level small cell bills. This is a balanced approach that will help speed the deployment of 5G. Right now, there is a cottage industry of consultants spurring lawsuits and disputes in courtrooms and city halls around the country over the scope of 253 and 332. That's the status quo. With this decision, we provide clear and updated guidance which will eliminate the uncertainty inspiring so much of that litigation. Some have also argued that we unduly limit local aesthetic review. But allowing reasonable aesthetic review, and thus only preventing unreasonable ones, does not strike me as a claim worth lodging. And some have asked whether this reform will make a real difference in speeding 5G deployment and closing the digital divide. The answer is yes. It will cut $2 billion in red tape. That's $8,000 in savings per small cell. Cutting these costs changes the prospects for communities that might otherwise get left behind. It will stimulate $2.4 billion in new small cell deployments. That will cover 1.8 million more homes and businesses without a penny in new taxes, and 97% of which are in rural and suburban communities. That is more broadband for more Americans. So in closing, I want to thank my colleagues for working to put these ideas in place. I want to thank Chairman Pai for his leadership in removing these regulatory barriers and putting all of these ideas on the table 17 months ago. And I want to recognize the exceptionally hardworking and usually highly caffeinated team at the FCC that helped lead this effort, including in the Wireless Bureau, Don Stockdale, Suzanne Tetreault, Garnet Hanley, Jonathan Campbell, Stacy Ferraro, Leon Jackler, Eli Johnson, Jonathan Lecter, Marcus Mayer, Betsy McIntyre, Daryl Pay, Jennifer Saulhouse, Jaming Sheng, and David Soretsky. I also want to thank the team in the Office of General Counsel, including Tom Johnson, Ashley Bazell, Bill Richardson, and Anjali Singh for their work on the item. It has my support.
Thank you, Commissioner Carr. Commissioner Rosenworcel.
All right. A few years ago, in a speech at a University of Colorado event, I called on the Federal Communications Commission to start a proceeding on wireless infrastructure reform. At the time, I suggested that if we want broad economic growth and widespread mobile opportunity, we need to avoid unnecessary delays in the state and local approval process. That, of course, is because they can slow deployment. I believed that then. I still believe it now. So when the FCC kicked off a rulemaking on wireless infrastructure last year, I had hopes. I hoped we could provide a way to encourage streamlined deployment nationwide. I hoped we could acknowledge that we have a long tradition of local control in this country, but also recognize more uniform policies across the country will help us in the global race to build the next generation of wireless services, or 5G. Above all, I hoped we could speed our infrastructure deployment by recognizing the best way to do so is to treat cities and states as our partners. In one respect, today's order, I believe, is consistent with that vision. We shorten the time frames permitted under the law for state and local review of the deployment of small cells, which of course are an essential part of 5G networks. I think this is the right thing to do because the shot clocks we now have were designed in an earlier era for much bigger wireless facilities. At the same time, we retain the right of state and local authorities to pursue court remedies under Section 332 of the Communications Act. And all in all, this strikes me as an appropriate balance. I appreciate that my colleagues were willing to work with me to ensure that localities have time to update their processes to accommodate these new deadlines, and that they are not unfairly prejudiced by incomplete applications. So I support this aspect of today's order. But in the remainder of this decision, my hopes did not pan out. Instead of working with our state and local partners to speed the way to 5G deployment, we cut them out. We tell them that going forward, Washington will make choices for them about which fees are permissible and which are not, about what aesthetic choices are viable and which are not, with complete disregard for the fact that these infrastructure decisions do not work the same in New York, New York, and New York, Iowa. So it comes down to this. 3 unelected officials on this dais are telling state and local leaders all across the country what they can and cannot do in their own backyards. This is extraordinary federal overreach. And I don't believe that the law permits Washington to run roughshod over state and local authority like this. And I worry that the litigation that follows will only slow our 5G future. For starters, the 10th Amendment reserves powers to the states that are not expressly granted to the federal government. In other words, the Constitution set up a system of dual sovereignty that informs all of our laws. To this end, Section 253 balances the interests of state and local authorities with this agency's responsibility to expand the reach of communication service. While Section 253A is concerned with state and local requirements that may prohibit or effectively prohibit service, Section 253D permits preemption only on a case-by-case basis after notice and comment. We do not do that here. Moreover, the assertion that fees above cost or local aesthetic requirements in a single city are tantamount to a service prohibition elsewhere stretches the statute beyond what Congress intended and legal precedent affords. In addition, this decision irresponsibly interferes with existing agreements and ongoing deployment all across the country. There are thousands of cities and towns with agreements for infrastructure deployment, including 5G wireless facilities, that were negotiated in good faith. So many of them could be torn apart by our actions here. If we want to encourage investment, upending commitments made in binding contracts is a curious way to go. Take San Jose, California. Earlier this year, it entered into agreements with 3 providers for the largest small cell-driven broadband deployment of any city in the United States. These partnerships would lead to 4,000 small cells on city-owned light poles and more than $500 million of private sector investment. Or take Little Rock, Arkansas, where local reforms to the permitting process have put it on course to become one of the first cities to benefit from 5G service. Or take Troy, Ohio. This town of under 26,000 has spent time and energy to develop streamlined procedures to govern the placement, installation, and maintenance of small cell facilities in a way that works for their community. Or take Austin, Texas. It has been experimenting with smart city initiatives to improve transportation and housing availability. And as part of this broader initiative, it started a pilot project to deploy small cells, and it has already secured agreements with multiple providers. This declaratory ruling has the power to undermine all of these agreements and countless more just like them. In fact, too many municipalities to count. From Omaha to Overland Park, Cincinnati to Chicago, and Los Angeles to Louisville have called on the FCC to halt this federal invasion of local authority. The National Governors Association and National Conference of State Legislatures have asked us to stop before doing this damage. The sentiment is shared by the United States Conference of Mayors, National League of Cities, National Association of Counties, and Government Finance Officers Association. In other words, every major state and municipal organization has expressed concern about how Washington is seeking to assert national control over local infrastructure choices, and in the process, stripping local elected officials and the citizens they represent of a voice. Yet, cities and states are told not to worry because with these national policies, wireless providers will save as much as $2 billion in costs, which will spur deployment in rural areas. But comb through the text of this decision. You will not find a single commitment made to providing more service in remote communities. Look for any statements made to Wall Street. Not one wireless carrier has said that this action will result in a change in its capital expenditures in rural areas. As Ronald Reagan famously said, trust but verify. You can try to find it here, but there is no verification. That's because the hard economics of deployment in rural areas do not change with this decision. Moreover, the asserted $2 billion in cost savings represents no more than 1% of investment needed for next-generation networks. It didn't have to be this way. So let me offer 3 ideas going forward. First, we need to be upfront and acknowledge we have a history of local control in this country, but also recognize that more uniform policies can help us be first to the future. So here's an idea. Let's flip the script and build a new framework. We can start with developing model codes for small cells and 5G deployment, but we have to make sure they are supported by a wide range of industry and state and local officials. Then we need to review every policy program from universal service to grants and low-cost loans at the Department of Commerce, Department of Agriculture, and Department of Transportation, and build in incentives to use these models. In the process, we create a more common set of practices nationwide. But to do so, we would use carrots instead of sticks. Second, this agency needs to own up to the impact of our trade policies on 5G deployment. In this decision, we go on at length about the cost of local review, but are eerily silent when it comes to the consequences of new national tariffs on network deployment. As a result of our escalating trade war with China, by the end of this year, we will have a 25% tax on antennas, switches, and routers, the most essential network facilities needed for 5G deployment. That's a real cost, and there is no doubt it will diminish our ability to lead the world in the deployment of 5G. Finally, in this decision, the FCC treats the challenge of small cell deployment with a bias towards more regulation from Washington rather than more creative marketplace solutions. But what if instead we focused our efforts on correcting the market failure at issue? What if instead of micromanaging costs, we fostered competition? One innovative way to do this involves dusting off our 20-year-old over-the-air reception device rules, or OTARD rules. Let me explain. The FCC's OTARD rules were designed to protect homeowners and renters from laws that restricted their ability to set up television and broadcast antennas on private property. In most cases, they accomplish this by providing a right to install equipment on property you control. And this equipment for video reception was roughly the size of a pizza box. Today, OTARD rules do not contemplate 5G deployment and small cells. But we could change that by clarifying our rules. And if we did, a lot of benefits would follow. By creating more siting options for small cells, we would put competitive pressure on public rights-of-way, which could bring down fees through competition instead of the government rate-making my colleagues prefer. Moreover, this approach would create more opportunities for rural deployment by giving providers more siting and backhaul options and creating new use cases for signal boosters. Add this up, and you get more competitive, more ubiquitous, and less costly 5G deployment. We don't explore these market-based alternatives in today's decision. We don't say a thing about the real costs that tariffs impose on our efforts at 5G leadership. And we don't consider creative incentive-based systems to foster deployment, especially in rural areas. But above all, we neglect the opportunity to recognize what is most fundamental. If we want to speed the way for 5G service, we need to work with cities and states across the country because they are our partners. For this reason, in critical part, I dissent.
Thank you, Commissioner. Perhaps the defining characteristic of the communications sector over the past decade is that the world is going wireless. The smartphone's introduction in 2007 may have seemed to some at the time an interesting novelty, but it was a precursor of a transformative change in how consumers access and use the internet. 4G LTE was a key driver in that change. Today, a new transition is at hand as we enter the era of 5G. At the FCC, we're working hard to ensure that the United States leads the world in developing this next generation of wireless connectivity so that American consumers and our nation's economy enjoy the immense benefits that 5G will bring. Spectrum policy, of course, features prominently in our 5G strategy. We are pushing a lot more spectrum into the commercial marketplace. On November 14th, for example, our 28 gigahertz band spectrum auction will begin, and after it ends, our 24 gigahertz band spectrum auction will start. And in 2019, we plan to auction off 3 additional spectrum bands. But all the spectrum in the world won't matter if we don't have the infrastructure needed to carry 5G traffic. New physical infrastructure is vital for success in 5G. That's because 5G networks will depend less on a few large towers and more on numerous small cell deployments that for the most part don't exist today. But installing small cells isn't easy, too often because of regulations. There are layers of sometimes unnecessary and unreasonable rules that prevent widespread deployment. At the federal level, we acted earlier this year to modernize our regulations and make our own review process for wireless infrastructure 5G fast. And many states and localities have similarly taken positive steps to reform their own laws and increase the likelihood that their citizens will be able to benefit from 5G networks. But as this order makes clear, there are outliers that are unreasonably standing in the way of wireless infrastructure deployment. So today, we address regulatory barriers at the local level that are inconsistent with federal law. For instance, big city taxes on 5G slow down deployment there and also jeopardize the construction of 5G networks in suburbs and rural America. So today, we find that all fees must be non-discriminatory and cost-based. That is not a radical decision. You can't discriminate, and the costs have to be reflective in the rates charged. And when a municipality fails to act promptly on applications, it can slow down deployment in many other localities. So we mandate shot clocks for local government review of small wireless infrastructure deployments. I salute Commissioner Carr for his leadership in developing this order. He worked very closely with many state and local officials to understand their needs and to study the policies that have worked at the state and local level. It should therefore come as no surprise that this order has won significant support from mayors, local officials, and state legislators. To be sure, there are some local governments that don't like this order. They would like to continue extracting as much money as possible in fees from the private sector and forcing companies to navigate a maze of regulatory hurdles in order to deploy wireless infrastructure. These actions are not only unlawful, they're also short-sighted. They slow the construction of 5G networks and will delay, if not prevent, the benefits of 5G from reaching American consumers. And let's also be clear about one thing. When you raise the cost of deploying wireless infrastructure, it is those who live in the areas where the investment case is the most marginal, rural areas or lower-income urban areas, who are most at risk at losing out. And I don't want 5G to widen the digital divide. I want 5G to help close that divide. In conclusion, I would like to again commend Commissioner Carr for leading this effort and to his staff for their diligent work. And I'm also grateful to the hardworking staff across the agency who have put many hours into this order. In particular, thanks to the Wireless Telecommunications Bureau, the Wireline Competition Bureau, the Office of Communications Business Opportunities, and the Office of General Counsel. We'll now proceed to a vote on the item. Commissioner O'Reilly?
Aye.
Commissioner Carr?
Aye.
Commissioner Rosenworcel?
Approve in part, dissent in part.
The chair votes aye. The item is adopted with editorial privileges granted as requested. Thanks to the staff for the great work. Madam Chairwoman, congratulations on the promotion. Madam Secretary, could you please take us to the next items on today's agenda?
Mr. Chairman and Commissioners, item 4 and 5 on your agenda today are Enforcement Bureau actions. Rosemary Harold, Chief of the Bureau, will give the introduction for each item, and then they will be presented consecutively.
Thank you, Madam Secretary. And as Ms. Harold and her staff are getting arrayed, I will introduce the process for this. Because these are enforcement-related orders, we are going to switch up the order slightly, as we have done in the past, in cases that involve the presentation of a notice of apparent liability or a forfeiture order at an open meeting. As with all open meetings, the Bureau circulated these items to every commissioner at least 3 weeks ago. But there's a longstanding practice at the agency that we don't publicly disclose the target of an investigation unless and until the commission decides to take enforcement action. For these items, this means that the agency formally votes on each item, then hears a brief presentation on each item from the Bureau before proceeding to any statements that the commissioners may have. This process ensures that the target will not be publicly disclosed until the FCC has voted to take action. We are following that precedent here, so we will now proceed directly to a vote on item 4 first, then on item 5, then we'll have presentations on both items, and then we'll turn to statements on both items from the dais. Vote on item number 4. Commissioner O'Reilly?
I'd ask you which is the difference between 4 and 5, but you probably can't tell me. It doesn't matter for my purpose. I approve in part and dissent in part on number 4 and number 5. Thank you.
Commissioner Carr?
I approve on both.
Commissioner Rosenworcel?
I approve on both.
The chair votes to approve on both, so we won't even have to call seriatim votes. So the items are adopted with editorial privileges granted, as I am confident will be requested. We will now turn to Ms. Harold for her introduction of these 2 enforcement items.
Thank you, Mr. Chairman and Commissioners. Thank you for your consideration and for your votes on today's 2 items. The first item is a forfeiture order addressing violations of the law and the Commission's rules by a large-scale robocall telemarketer. The second item is a notice of apparent liability for forfeiture addressing apparent violations of the law and the Commission's rules by a different telemarketer. With me at the table are Jonathan Garvin, Acting Legal Advisor, Christy Thompson, Chief of the Telecommunications Consumers Division, or as we know it, TCD, Parl Desai, Deputy Chief of TCD, and Kimberly Taylor and Shante Willis, Attorney Advisors in TCD. I would also like to thank Lisa Gelb and Rick Hindman for their work on these items. Kimberly will present the forfeiture order, and then Shante will present the notice of apparent liability.
Thank you, Rosemary. Good morning, Chairman and Commissioners. This forfeiture order imposes a penalty in the amount of $82,106,000 against Mr. Philip Roselle and his company's Best Insurance Contracts, Inc. and Wilmington Insurance Quotes for spoof robocalls in violation of the Truth and Caller ID Act, codified in Section 227 of the Communications Act. Through its investigation, the Bureau determined that Roselle was responsible for placing more than 21 million spoof telemarketing robocalls to consumers between late October 2016 and January 2017. Roselle falsified the caller ID information of the robocalls by inserting an unassigned phone number in place of Roselle's caller ID information. In August 2017, the Commission adopted a notice of apparent liability for forfeiture against Roselle and his companies for violations of the Truth and Caller ID Act. Roselle responded to the NAL. He admitted that he had made the spoof robocalls during the relevant time period and that the calls were made through an account he had set up using a calling platform. Roselle claimed, however, that the evidence does not support a finding of intent to cause harm or wrongfully obtain anything of value as required by the Truth and Caller ID Act. The order sets forth the bases for the Commission's finding that Mr. Roselle had the requisite intent. Roselle also argued that the Commission's proposed forfeiture should be reduced because of an inability to pay. The forfeiture order rejects Roselle's argument, noting that the ability to pay is only one factor among several that the Commission must consider under Section 503 of the Act. Roselle is highly culpable, and his conduct was egregious. Roselle argued that the forfeiture order should apply only to Best Insurance Contracts and not to Mr. Roselle individually. The forfeiture order finds Philip Roselle, along with the companies he created, Best Insurance Contracts and Wilmington Insurance Quotes, are properly held liable. Finally, Roselle requested that the Commission exercise its discretion and designate the case for hearing. The forfeiture order finds no justification for doing so. Roselle's spoofed calls were disruptive to consumers, businesses, and to the network of a major medical paging company, causing service disruptions and putting lives at risk. The Enforcement Bureau appreciates the Commission's adoption of this item. My colleague will now present the second enforcement item.
Good morning, Mr. Chairman and Commissioners. This notice of apparent liability imposes a penalty in the amount of $37,525,000 against Affordable Enterprises for making spoof telemarketing calls in apparent violation of the Truth and Caller ID Act, codified in Section 227 of the Communications Act. After conducting an extensive investigation, the Bureau determined that between July 2016 and September 2017, Affordable Enterprises made more than 2.3 million apparently unlawful spoof telemarketing calls to consumers throughout Arizona, many of whom had placed their residential numbers on the National Do Not Call Registry. Affordable knowingly falsified the caller ID information by inserting phone numbers belonging to innocent consumers that were unaffiliated with Affordable, or numbers that were unassigned, or numbers that belonged to prepaid cell phones that Affordable referred to as burner phones. The evidence shows that Affordable apparently spoofed the caller ID information to wrongfully obtain something of value, specifically calling consumers on the Do Not Call registry in order to generate sales and evade detection by consumers and law enforcement. The spoofed calls were also made with an apparent intent to harm. Affordable's calls were particularly harmful to innocent consumers whose numbers Affordable displayed in the caller ID and who were left vulnerable to an overwhelming amount of callbacks and angry messages from Affordable's other victims. Because of the apparent unlawful intent behind Affordable's actions to falsify caller ID information, Affordable's spoofing apparently violated the Truth and Caller ID Act. The penalty proposed is based on the Bureau's review of the call records for 37,525 apparently illegal spoof telemarketing calls that Affordable made to consumers in Arizona. The Bureau plans to release contemporaneously a citation against Affordable for making telephone solicitations to consumers registered on the National Do Not Call Registry in violation of the Telephone Consumer Protection Act.
The Enforcement Bureau appreciates the Commission's adoption of both items. Thank you.
Thank you, Ms. Willis, and as well Ms. Taylor for your presentations. We'll now turn to comments from the bench, beginning with Commissioner O'Reilly.
I have a statement for number 4 that I'll submit for the record, and no statement on number 5. Thank you.
Okay. Commissioner Carr?
No statement on either. Thank you for your work on this.
Commissioner Rosenworcel?
All right. I do have a few things to say. The first is thank you to the Enforcement Bureau for your terrific work. And the second, which I didn't anticipate saying, is both of my phones up here got a robocall since this meeting started.
I think that was Mike.
I know his number. If you think we're drowning in robocalls now, get ready, because what's happening here is not actually funny. The Washington Post just reported by next year we're going to reach a new high water mark. In 2019, about half of all cell phone calls will come from scammers. This is insane. And it's great that this agency is issuing a forfeiture order and a notice of apparent liability today, but it is crazy to think that these individual actions are going to do the trick and staunch the flow. With this one-by-one effort, we are trying to empty the ocean with a teaspoon. We need a better approach. We need to develop a commission-level policy statement to articulate this agency's goals and efforts to reduce robocalls. We need to set deadlines. It's been roughly 2 years since this agency identified Shaken and Stir as a call authentication technology that can reduce robocalls. And in the meantime, Canada went ahead and set a 2019 deadline to put this technology in place. We should be doing the same as our neighbors to the north. We should have field hearings and seek technical expertise from far and wide. And closer to home, we need to respond to every outstanding court remand on robocalls and petition before this agency expeditiously. Just this week, NBC News reported on the same statistics cited by the Washington Post. It sought comment from this agency. The best we had to offer was an unnamed official who said, an industry-led effort is the fastest way, and we hope some companies will implement it. I like hope. But hope alone is not going to fix this problem. It takes effort, and it's time for this agency to offer real robocall resistance, because the flood of these calls is destroying something essential, and that's trust in our communications network.
Thank you, Commissioner. During my tenure as FCC chairman, I've had the chance to set the agenda for 20 monthly meetings. And at almost half of those meetings, we have voted on measures to fight the scourge of unlawful robocalls. This proactive strategy follows through on what I said shortly after becoming chairman. Combating illegal robocalls would be the FCC's top consumer protection priority, which it was not during the previous 3 years. Today, we take further steps to address this priority by approving 2 major enforcement actions. The first involves Philip Rozelle. By making unsolicited calls to consumers, Rozelle generated leads for insurance products that he sold. Last year, we found he and his company apparently liable for $82 million for violating the Truth in Caller ID Act. Rozelle was responsible for more than 200,000 spoofed robocalls each and every day, 21.5 million altogether over a 3-month period from late 2016 through early 2017. The second enforcement action is a notice of apparent liability against Affordable Enterprises of Arizona. Affordable ran a telemarketing scheme to gain new customers and increase sales of its home improvement and remodeling services. This company apparently made over 2 million unlawful spoofed telemarketing calls in just a 14-month period. So we're proposing a penalty of over $37 million for apparent violations of the Truth in Caller ID Act. This is why this matters from a consumer perspective. The Enforcement Bureau's ABLE investigation unearthed details about Affordable's scheme after investigating a sampling of 13 separate numbers used by Affordable for caller ID purposes from July of 2016 to September of 2017. Affordable used these 13 numbers to make over 2.3 million telemarketing calls during this period. And not one of these numbers displayed correct caller ID information to show that the calls came from Affordable or otherwise listed Affordable as a subscriber of record. 4 of those sample numbers used by Affordable were assigned to innocent consumers. One of those consumers claimed to have received more than 5 calls a day from people irate that they were receiving unwanted calls from her number and demanding that she stop. This consumer said that she was overwhelmed by these calls, and no wonder. The Bureau's investigation confirmed that Affordable had made more than 48,349 calls alone using her phone number during the period that it was assigned to this consumer. Well, this conduct is outrageous and unacceptable. Now, of course, enforcement actions alone will not solve the problem of unlawful robocalls. And that is why we've been busy working on a variety of initiatives to address this issue. In response to our charge, the North American Numbering Council, an FCC advisory committee, has set out the next steps for implementing a nationwide call authentication system designed to stamp out robocalls from bad actors. And the private sector is now stepping up the governance system for authenticating calls industry-wide. We are monitoring these efforts and will consider whether any commission action is needed to ensure that milestones are met in a timely manner. But make no mistake about it, penalizing those who spoof caller ID information and flood Americans' phones with unlawful robocalls must be a component of any effective strategy for combating this scourge. So I want to thank the staff of the Enforcement Bureau for the careful sleuthing and the hard work in bringing these cases forward, from the Enforcement Bureau, as well as the Consumer and Governmental Affairs Bureau and the Office of General Counsel. The Commission appreciates your work. With that, we will turn to the Secretary to take us to the next item on the agenda, having voted on the enforcement items.
Thank you, Mr. Chairman and Commissioners. Item 6, entitled FCC Form 325 Collection, Modernization of Media Regulation Initiative, will be presented by the Media Bureau, and Sarah Weitzel, Deputy Chief of the Bureau, will give the introduction.
Madam Secretary. Ms. Weitzel, if whenever you are ready, the floor is yours.
Good afternoon, Mr. Chairman and Commissioners.
Afternoon.
The Media Bureau is pleased to present to you a report and order that eliminates the Form 325 Annual Report of Cable Television Systems filing requirement. This marks another step in the Commission's ongoing effort to modernize our rules by eliminating outdated, unnecessary, or unduly burdensome regulations that no longer serve the public interest. Joining me at the table are Brendan Holland, Ty Bream, and Jamil Kadre of the Bureau's Industry Analysis Division. Jamil will present the item.
Mr. Chairman and Commissioners, we present to you this report and order which eliminates the requirement set forth in Section 76.403 of our rules that cable operators file Form 325 with the Commission. Form 325 collects operational information from cable television systems nationwide, including data about subscriber numbers, equipment information, physical plant information, frequency and signal distribution information, and programming information. The Commission first developed the form in 1966, and the last significant modification of the form was nearly 20 years ago. In November 2017, the Commission issued a Notice of Proposed Rulemaking evaluating the continued need for the Form 325 information collection and proposing to streamline or eliminate the form. The report and order finds that marketplace, operational, and technological changes have overtaken the utility of Form 325 and rendered it increasingly obsolete, as reflected by the Commission's limited use of Form 325 data in recent years. The report and order also finds that much of the information collected by the form can be obtained from alternative sources without the burden imposed on cable operators and the Commission by the Form 325 filing requirement. Because this filing requirement no longer provides sufficient benefits to justify its retention, the report and order finds that the elimination of the Form 325 data collection is in the public interest. The Media Bureau recommends that the Commission adopt the report and order and requests editorial privileges to make any necessary technical or conforming edits. Thank you.
Thank you for that presentation. We'll now turn to comments from the bench, beginning with Commissioner O'Reilly.
Thank you, Mr. Chairman. The premise at the heart of this rather innocuous but important proceeding is eliminating a reporting requirement that no longer makes any sense. Arguments can be made that Form 325 data is duplicative or that it's no longer relevant. Under either scenario, the action taken in this item is appropriate and earns my strong support. On a larger note, This item is a part of a series of proceedings to help modernize existing commission regulations imposed on broadcast and cable companies. It is both appropriate and exciting to see this one completed, and I hope we can quickly move to the other 8 or so other items that have already been briefed and should be ready to go to final action. Concurrently, we should turn our attention to finding the next dozen, and then the next dozen, and the dozen after that of unnecessary rules and reporting requirements that can be eliminated. I thank the chair.
Thank you, Commissioner O'Reilly. Commissioner Carr.
Mr. Chairman, as you know, your punitively deregulatory media agenda has permanently altered the landscape of my Saturday mornings. I've been distracting my kids from the loss of switching station Sam, who, if you remember, was upscaled to corporate due to one of your prior reforms. I've been distracting them by reading from Form 325, the annual report of cable television systems. And now that too is gone. You might say, no big deal, just move up to Form 326. But it'll probably be news to you that Chairman Mark Fowler beat you to the punch and eliminated that one back in 1983. So now that leaves us to moving on to Form 327, which is the application for cable television relay service station license, but it just doesn't have the same right. Nonetheless, I'll be voting to approve. And as Commissioner O'Reilly said, I do want to thank the staff in all seriousness for the work they've done in this and a lot of other proceedings. You've been moving at an unprecedented and needed pace to bring our media rules into the modern era, so thank you.
Sacrificing family for deregulation. That's impressive, Commissioner Carr. Commissioner Rosenworcel. The musician Frank Zappa once wrote, "It isn't necessary to imagine the world ending in fire or ice. There are 2 other possibilities. One is paperwork, and the other is nostalgia." Now, I will admit that my statements sometimes invoke nostalgia, but the FCC at least is doing what it can to ensure that the world doesn't end in paperwork. At the vanguard of that effort is our Modernization of Media Regulation Initiative. For some time, we've been looking to free cable operators and broadcasters from unnecessary paperwork. And today, over Commissioner Carr's personal objections, we advance this goal by eliminating something called Form 325. Now, back when cable television was young, the FCC began collecting data via Form 325 to see how cable systems were developing. Among other things, Form 325 tracks information on subscriber numbers, equipment, frequency, and signal distribution. But the cable industry has changed drastically over the past half-century, and so too has information about them. There are plenty of other sources of industry information today, and that is why the Commission in recent years has rarely used the data collected by Form 325. Instead, we've relied on information from other authoritative sources. In sum, it is a burden to submit and collect this information with little benefit for all involved. And so today we make the logical decision to free cable operators from the burden of filling out Form 325. I'd like to thank the dedicated Commission staff for their ongoing work to modernize our media regulations and to save the world from ending in paperwork, in particular from the Media Bureau and the Office of General Counsel. Thanks for your work on this Modernization of Media Regulation Initiative. There's more to come, but this is an important step today. With that, we'll proceed to a vote on the item. Commissioner O'Reilly?
Aye.
Commissioner Carr?
Approve.
Commissioner Rosenworcel?
Aye.
The chair votes aye as well. The item is adopted with editorial privileges granted as requested. Thanks to you all for the hard work. Madam Secretary, could you please take us to the next item on today's agenda?
Mr. Chairman and Commissioners, Item 7, entitled Toll-Free Assignment Modernization, Toll-Free Service Access Codes, will be presented by the Wireline Competition Bureau, and Chris Monteith, Chief of the Bureau, will give the introduction.
Thank you, Madam Secretary. Ms. Monteith, whenever you and the intrepid team WCB are ready, the floor is yours.
Good afternoon, Mr. Chairman and Commissioners.
What afternoon?
The Wireline Competition Bureau presents for your consideration a report and order on modernizing toll-free number assignment. This item, if adopted, will make toll-free numbers available on a more equitable and efficient basis by ensuring that desirable numbers are assigned to entities that value them most. I would like to thank the entire Wireline team for their hard work on this item, as well as our colleagues in the Consumer and Governmental Affairs, Enforcement, Public Safety and Homeland Security, and Wireless Telecommunications Bureaus, and in the Offices of General Counsel and Strategic Planning and Policy Analysis for their review and helpful feedback. Seated at the table with me from the Wireline Competition Bureau's Competition Policy Division are Daniel Kahn, Division Chief, Ann Stevens, Deputy Division Chief, Heather Hendrickson, Assistant Chief, and Matt Collins, Attorney Advisor. Joining us from the Wireless Telecommunications Bureau's Auctions and Spectrum Access Division is Gary Michaels, Deputy Division Chief of that division. Matt will now present the item. Thank you.
Mr. Chairman and Commissioners, good afternoon.
Afternoon.
This report and order, if adopted, will revise our toll-free number assignment rule to provide the Commission with flexibility to assign toll-free numbers, including by auction. Assignment of numbers by auction will ensure that they are assigned to the parties that value them most and promote the efficient allocation of desirable toll-free numbers. The report and order establishes a single-round sealed bid victory auction of over 17,000 mutually exclusive numbers in the 833 code, which were set aside in the process of opening that code. The 833 auction will serve as an experiment to determine how to most effectively use competitive bidding to assign toll-free numbers. The Wireline Competition Bureau will release a report after the completion of the auction, providing the Commission with data and recommendations to consider for future toll-free number assignments. The report and order establishes a process by which government and nonprofit entities may petition that a number be set aside from the 833 auction for use for public health and safety purposes. The report and order also directs that net proceeds from the 833 auction will offset the costs of toll-free numbering administration. Complete procedures for the 833 auction will be established in subsequent public notices. The report and order revises our toll-free rules in two additional ways. First, it creates an exception to the brokering, hoarding, and warehousing rules for numbers assigned in an auction. Doing so will allow for the development of a secondary market for numbers assigned via competitive bidding, thereby improving auction efficiency by allowing numbers to be transferred after the completion of an auction. Second, the report and order makes ministerial revisions to our toll-free rules to make them consistent with the other revisions set forth today and with industry terminology and practice. The Wireline Competition Bureau recommends adoption of this item and requests editorial privileges extending only to technical and conforming edits. Thank you.
Thank you, Mr. Collins, for your presentation. We'll now turn to comments from the bench, beginning with Commissioner O'Reilly.
I thank the chair. In an age where organizations increasingly communicate with their customers via internet platform-based platforms and applications, and unlimited domestic calling plans are ubiquitous, toll-free numbers possess an anachronistic quality. But despite representing relics of legacy telephone system, toll-free numbers still require Commission attention. Consistent with the Commission's statutory obligation to make toll-free numbers available on an equitable basis, I support exploring auctions as a way to depart from the Commission's unfair and outdated first-come, first-served allocation method. Giving away desirable numbers for free undermines justice and economic efficiency and creates perverse rent-seeking incentives for restborgs. As in other cases of allocating scarce public goods, more competitive bidding and less command and control is generally the best answer. A robust secondary market will further promote the interest of equity and efficiency and ensure that valuable resources are not tied up in enforcing ineffective rules against reassignment. Despite my support for implementing an 833 auction, I would have pushed this experiment further by extending market-based principles to the assignment of the auctioneer role itself. While Somos may be competent to administer the toll-free numbering database, managing an auction is an entirely different skill set. And without any concrete analysis of Somos costs of running the auction submitted to the record, we run the risk of undermining the auction's financial success and creating uncertainty in Somos's future tariff filings. This forces me to ponder exactly how is it that no one asked Somos for its estimated costs and what they would be. For future toll-free auctions, I urge the Commission to subject the auctioneer role to a competitive bidding process rather than designate it to the toll-free administrator automatically. I also view the decision to forego multiple round bidding as a missed opportunity. The Commission has repeatedly stated that simultaneous multi-round auctions are preferable to other bidding mechanisms by providing the best opportunity for price discovery, value maximization, and bidding flexibility. In the case of toll-free numbers, which may be substitutable in certain cases, we should enable bidders to gain insight into other parties' valuations and pursue backup strategies. Particularly if the auction turns out to be a financial success, I hope that future toll-free auctions, the Commission will experiment with multi-round design. Finally, while the Commission's traditional practice of distributing toll-free numbers for free artificially skews demand, one of the strengths of an auction is that it allows the market to determine the value of toll-free numbers. We must not undermine this gain by creating further distortions in the toll-free number market. Unfortunately, the item does just that by directing the net positive proceeds of the auction towards defraying the toll-free numbering administration costs. This is a mistake for two reasons. First, it's unfair to taxpayers. A toll-free number is a scarce public good, and any net proceeds of an auction belong in the Treasury, not in the pockets of toll-free subscribers. Second, lowering the fees associated with toll-free reservations artificially subsidizes and stimulates toll-free subscription. We should not be in the business of picking winners and losers for technology, and I fear that the item's method for distributing proceeds frustrates the Commission's goal of improving efficiency and equity in the nation's toll-free numbering administration. Despite these deficiencies and the item's unnecessary and nebulous reliance on Section 201B for regulatory authority, I nonetheless extend my support for the report and order. I look forward to learning any accompanying lessons from this experimental auction. I thank my colleagues for working with me to improve the item. I thank the chair.
Thank you, Commissioner. Commissioner Carr.
Thanks. A video recently circulated of Missouri Congressman Billy Long displaying a unique set of skills during a House Energy and Commerce hearing. For those of you who don't know, Congressman Long is an auctioneer by training, and he owned auctions company before he became a member of Congress. So when the hearing was disrupted by a protester, Congressman Long used his auction bid calling skills to draw attention away from the protest and get the hearing back on track. Now, what, you might ask, does this have to do with the FCC and the toll-free numbers item in particular? Well, over the past few decades, the FCC has become something of an auctioneer itself. Thanks to our spectrum auctions, the U.S. has now freed up and allocated more spectrum for commercial use than any other country in the world. And the FCC has experienced so much success with auctions that we've begun using them in the Universal Service Program to modernize the way we distribute support. So I'm glad to see we're now carrying this experience over into toll-free numbers. In the Communications Act, Congress directed the FCC to make these numbers available on an equitable basis. And historically, we interpreted that to mean handing them out, these valuable toll-free numbers, on a first-come, first-served basis. But this approach has proven to be inefficient and susceptible to arbitrage and gaming. So it makes sense to test whether a market-based mechanism can better allocate toll-free numbers. I'm particularly glad we take steps to establish a secondary market for toll-free numbers, which will help ensure that these numbers are put to their highest and best use. So thank you to the staff of the Wireline Bureau for your work on the item. I look forward to seeing the result of the upcoming auction of 833 toll-free numbers and the takeaways for future auctions. Thanks.
Thank you, Commissioner. Commissioner Rosenworcel.
Today we begin what is really a grand experiment with toll-free numbers. And to understand why that's true requires, of course, a bit of explanation. So let's back up. Under the law, the FCC has a duty to ensure that the distribution of toll-free numbers is equitable. For decades, equitable has meant that this agency managed distribution of 800 numbers and their brethren through a command and control system. It worked like this. Toll-free numbers were provided on a first-come, first-served basis, and a secondary market for these numbers was strictly prohibited. But a quick online search will tell you all you need to know about the deficiencies with this approach. On the internet, you will find that there is a vibrant marketplace where anyone can buy a toll-free number from entities that openly flout our rules. You know, it's fair to ask if there's a better way, and that's what we do here. We set up a sandbox experiment. We depart from our command and control past and announce an auction for the distribution of the 833 area code, our newest toll-free number. We also liberalize policies with respect to secondary market transactions for numbers that are auctioned. I think this is a smart undertaking. But as with any experiment, we have a lot to learn. It is imperative that the FCC study our 833 effort, how it operates, and the outcomes that result, and then carefully consider whether or not it works better than our traditional means of toll-free number distribution. I know I will be paying close attention, especially to the audit that will follow this auction, one that my colleagues have agreed to at my request. There is one other request that I had that my colleagues worked with me on, and for that I'm grateful. The rulemaking that preceded this decision asked questions about how to ensure public entities that may not have the resources to meaningfully participate in an auction should be treated when toll-free numbers are expanded, as they will be here with 833. These include government authorities and also nonprofits providing essential health and safety services. Today, nonprofits operate a number of toll-free hotlines that are a critical part of public safety. These include the National Capital Poison Control Hotline, which helps manage poison emergencies, frequently with children. They include the National Child Abuse Hotline, which needs no explanation. The National Center for Missing and Exploited Children runs a hotline to prevent childhood victimization and leads the fight against abduction, abuse, and exploitation of our youngest. In fact, last year alone, the center responded through its hotline to more than 10,000 reports of child sex trafficking. The National Runaway Hotline is also a nonprofit that provides public benefit, as does the National Sexual Assault Telephone Hotline, which reported a 42% increase in calls just this last weekend. The initial draft of today's decision left all of these hotlines and many nonprofit public health and safety organizations just like them out in the cold. Without the financial resources to compete, they were effectively shut out of the auction and precluded from preserving their numbers in any toll-free expansion. This has been fixed, and I believe the decision now serves the public interest. As a result, this grand experiment with toll-free area code 833 has my full support.
Thank you, Commissioner. The FCC has a history of doing innovative things with auctions. As we have heard, just last month, we completed the Connect America Fund Phase 2 reverse auction to allocate nearly $1.5 billion to deploy fixed broadband to unserved parts of rural America. This is an important departure from the old way of doing things. It efficiently targets funding where it's needed most and promotes competition. Of course, until a few decades ago, it was thought to be radical to award spectrum via auctions. But it didn't take long after auctions began in the early 1990s for nearly everybody to concede their wisdom. So far, the FCC has successfully held 90 spectrum auctions. And following our lead, many other countries around the world have followed our approach. And so today I'm excited that we are extending our use of this market-based mechanism of the auction. Currently, as Mr. Collins observed, toll-free numbers are allocated through a system that effectively rewards regulatory arbitrage. The winners are typically those with computer systems that can quickly grab desirable numbers from the toll-free number administrator database. This means that numbers might not be put to their highest valued use. But going forward, we will let the market allocate more efficiently the roughly 17,000 toll-free numbers in the new 833 area code, numbers in which many have expressed an interest. And so thank you to the staff that has worked tirelessly on this effort, from the Wireline Competition Bureau, the Wireless Telecommunications Bureau, the Office of General Counsel, and the Office of Strategic Planning and Policy Analysis. We will now proceed to a vote on the item. Commissioner O'Reilly?
Aye.
Commissioner Carr? Aye. Commissioner Rosenworcel?
Aye.
The chair votes aye as well. The item is adopted with editorial privileges granted as requested. Thank you to the staff for the great work. Madam Secretary, could you please announce the next item on today's agenda?
Mr. Chairman and Commissioners, the final item on your agenda today will be presented by the International Bureau and is entitled amendment of Parts 2 and 25 of the Commission's rules to facilitate the use of Earth stations in motion communicating with geostationary orbit space stations in frequency bands allocated to the fixed satellite services. Thomas Sullivan, Chief of the Bureau, will give the introduction.
Thank you, Madam Secretary. Mr. Sullivan, batting cleanup. Bring us home.
Thank you for the closing roll. Good afternoon, Mr. Chairman and Commissioners.
Afternoon.
The International Bureau is very pleased to present you with this report and order and further notice of proposed rulemaking. This item recommends streamlining, consolidating, and harmonizing the Commission's rules governing Earth stations that provide satellite-based services on ships, aircraft, and vehicles, collectively known in the industry as Earth Stations in Motion, or eSIMs. I'm joined at the table by Troy Tanner, Deputy Chief of the International Bureau, Jose Albuquerque, Chief of the Satellite Division, and Cindy Spears, Attorney Advisor in the Satellite Policy Branch. I would like to acknowledge the contributions from other staff in the International Bureau on this item, and from our colleagues in the Office of General Counsel, Office of Engineering and Technology, and the Wireless Telecommunications Bureau. Cindy will present the item.
Thanks, Tom. Good afternoon, Mr. Chairman and Commissioners.
Afternoon.
This report and order and further notice of proposed rulemaking concludes the first stage of this proceeding initiated to streamline the Commission's rules that govern the licensing and operation of Earth Station in Motion, or eSIMs. eSIMs is an umbrella term that includes Earth stations that transmit and receive while in motion aboard vessels on water, land-based vessels, and vehicles and aircraft. The regulation of these Earth stations developed over the course of a decade in separate but overlapping proceedings and is divided by the category of the area where the Earth stations operate. The Commission's current rules provide for blanket licensing for these Earth stations communicating with C-band and Ku-band geostationary orbit satellites in the Fixed Satellite Service, or GSO-FSS. This proposed order consolidates into a single section the rules governing the licensing and operation of these different categories of eSIMs operating in different frequency bands, which currently are included in 4 different sections of Part 25. This new section also allows for eSIM operations in the conventional Ka-band frequencies as an application of the FSS, communicating with satellites in the GSO-FSS on a primary basis. If these changes are adopted, applications for eSIMs operations in the Ka-band would be able to be routinely processed. This would be more efficient for both our applicants and the Commission staff. Finally, the order proposes to eliminate repetitive and unnecessary rules. For example, the order eliminates certain eSIM rules by referring to existing provisions in other rules that apply to other GSO-FSS Earth stations. It also eliminates rules requiring precise pointing of Earth station antennas, which are unnecessary in view of the way our rules restricting transmission toward adjacent satellites are worded. The further notice of proposed rulemaking seeks comment on allowing eSIMs to operate in all of the Ku bands in which Earth stations at fixed locations operating in the GSO-FSS satellite networks can be blanket licensed. This includes the ranges 10.7 to 10.95 gigahertz and 11.2 to 11.45 gigahertz on an unprotected basis with respect to other services. And the further notice seeks comment on whether these operations could in fact be conducted without protection from interference. For the Ka-band, the further notice seeks comment on allowing eSIMs to receive signals from GSO-FSS satellite space stations on a secondary basis in the 17.8 to 18.3 gigahertz band, and on a primary basis in the 19.3 to 19.4 and 19.6 to 19.7 gigahertz band. It also seeks comment on whether to allow eSIMs to communicate with the GSO-FSS satellites in the 18.8 to 19.3 gigahertz and 28.6 to 29.1 gigahertz frequency bands on an unprotected non-interference basis with respect to NGSO-FSS satellite systems. All of these changes would continue to provide additional flexibility to the growing eSIMs market. The International Bureau recommends adoption. of this report and order and further notice of proposed rulemaking and request editorial privileges for technical and conforming edits.
Thank you, Ms. Spears. Mr. Sullivan for the presentation. We'll now turn to comments from the bench, beginning with Commissioner O'Reilly.
Thank you, Mr. Chairman. Having been a recent cross-country traveler on an older airplane without any entertainment system, my appreciation of adequate broadband on moving vehicles has only increased. As any frequent flyer or non-frequent flyer knows, the Wi-Fi on airplanes is generally lacking. However, this shortcoming does not have to be the case. With this fairly technical item before us, the Commission streamlines and consolidates the rules for eSIMs, permits operations in additional spectrum bands to facilitate communications with GEO satellites, and seeks comment on future frequencies for eSIMs. Hopefully, our actions will facilitate and improve satellite broadband on ships, planes, trains, and automobiles, not only to provide access to Americans as they travel, but also for the benefit of commerce and other uses. I am going to approve.
Thank you. Oh, sorry. Thank you, Commissioner. Commissioner Carr.
Thanks. It often takes the modern-day version of duct tape and baling wire to deploy broadband in the hardest-to-serve parts of the country. This work is done by people with names like Bear, who works in the Nevada desert bringing broadband to a community that didn't even have telephone service until the 1960s. People like Blake, who strings aerial fiber on utility poles hundreds of miles above the Arctic Circle. And people like Darren and Matt, who worked in the 106-degree Arizona heat 2 weeks ago to deploy our provider's first 5G small cell in the state. These are tough jobs. And right now, we have the best crews in the world working to deploy more broadband. Today's decision aims to make it a little easier to serve rural, remote parts of the country. We do this in a way that admittedly isn't directly connected to the entry point I chose for this statement, but it entertained me, so I went with it, by proposing to give satellite providers greater flexibility in reaching consumers who often can't be served using other technologies. I'm glad that we're looking to promote new services and innovations in the satellite bands, so the item has my support. Thank you.
Thank you, Commissioner. Commissioner Rosenworcel.
This is so cool. We're making it possible for some of the most modern satellite technologies to expand the reach of our networks to some of the most challenging environments, and that's on planes, ships, and vehicles. And we're doing it by facilitating the operation of eSIMs with fixed satellite service geostationary orbit satellites in the Ka band, and by simplifying our rules to facilitate investment and reduce regulatory burden. I think a fresh look at these rules is warranted because new capabilities have allowed the development of more spectrally efficient, ultra-small terminals that can provide broadband communications to support voice, video, and high-speed data. That means these satellite systems can support a whole new range of global connectivity that will probably lead to much more efficient and effective transportation systems. That's exciting, so this has my full support.
Thank you, Commissioner. During a recent visit to Moab, Utah, I held a video conference with the school superintendent of a fairly remote district in the state. He told me that the district's student athletes often had to travel several hours in order to play away games. Fortunately, some of their school buses had connectivity, which enabled kids to do their homework on some of these long drives. And that vignette got me thinking about on-the-road connectivity, including the need to promote satellite-related Earth stations in motion, or eSIMs, as the cool kids say. eSIMs, as Ms. Spears has pointed out, are used to deliver broadband to ships, vehicles, and aircraft, basically any non-stationary platform, especially those that cannot be served using other communications technologies. Today, the FCC advances the use of eSIMs in several ways. First, we allow them to operate in more satellite frequencies than they currently use. We aim to spark innovation and investment, encourage deployment, and hopefully connect even more consumers in this fast-growing segment of the satellite marketplace. Second, we explore whether to add even more spectrum bands to the eSIMs approved list. And third, we simplify the 3 sets of rules for the 3 different kinds of eSIMs by establishing a single unified regulatory framework. This will provide certainty for eSIMs operators and customers. Our forward-thinking approach to eSIMs reflects our overall strategy for closing the digital divide, to encourage any and all technologies that can connect those for whom broadband has for too long been an aspiration more than a reality, including many other students who endure very long bus rides in places like remote Utah. So my thanks to the International Bureau, the Office of Engineering Technology, the Wireless Telecommunications Bureau, and the Office of General Counsel for the work on this item. We'll now proceed to a vote. Commissioner O'Reilly.
Aye.
Commissioner Carr.
Aye.
Commissioner Rosenworcel.
Aye.
Chair votes aye as well. The item is adopted for the digital privileges granted as requested. Thanks to the staff. Would any of my colleagues like to make any announcements at this time? Oh, Commissioner O'Reilly.
Well, there's been a lot happening on Team O'Reilly in the last couple of months. On a personal note, my family welcomed Tess Caroline to our house, and it's been a blessing. I put some pictures up there for you to take a look at. They're kind of in backwards order. It's very, the farthest one to the right is she's contemplating life. The second one, she's listening to me talk about KidVid. And the third one, I replayed last month's FCC open meeting. Didn't go so well. Thank you so very much. But turning to some personnel changes in my office, we welcomed Ariel Roth to our wireline function. She was a wireline advisor in the she was a legal advisor in the Wireline Bureau and spent much work on the Commission's recent telehealth NOI. She formerly worked with former Commissioner Harold Furchgott Roth, no relation, at the Hudson Institute, and is a graduate of McGill University Law School and the University of Toronto with a degree in philosophy. So I hope you will continue to welcome her to our office.
You
and
should
our
stand
work.
as well so we can welcome you.
See, I don't do that in my office, see?
Oh.
But, second, I wanted to welcome our fall legal intern, Kagan Despain. I hope I got that right. He is attending BYU Law School with a graduation expected in 2020. His undergrad was at Westminster College, which is in Salt Lake City, Utah. And he's been incredibly helpful on a number of projects that we've thrown at him so far. The last reason I bother you today is to actually say goodbye to someone in my office. I put out an announcement to this effect, but I wanted to personally do this publicly to thank Brooke Erickson of my staff, my chief of staff, who was exiting at the end of October. First, let me just thank Brooke for her many years of public service. It's not said enough for people who set aside career ambitions to go work for the federal government, many as we have, as people at the commission have, and I can't thank her for her time for the American people. Well, I will find someone to fill her particular role. Brooke is actually irreplaceable. Her work on 911 feed aversion or media modernization or KidVid or so many more was inspirational and breathtaking. Her Capitol Hill experience was invaluable to me. And I normally wouldn't do this goodbye speech now since we've got some time to go. But Brooke is actually getting married in a couple weeks, and her honeymoon will take us through our next meeting. So I wanted to properly thank her for all the work that she was able to do in my office and appreciate the benefits that she brought to the American people. So thank you very much. And with that, I'm concluded.
All right, sure. Well, the maternity ward that is JRO 2.0 continues. We are welcoming baby number 4, Jessica Martinez, in my office. Late at night on August 31st, gave birth to Genevieve, and she's joining her older brother, Augie, and of course, mom and dad at home, and all is well. And we're excited. Though we miss having Jessica in our office, we know she's busy with important stuff right now. And I warn you that there's more babies to come. So if anyone wants to drink water in our office, you are forewarned.
No, we're not coming by at all.
Thank you, Commissioner. Commissioner Carr.
Thanks. I'd like to introduce our fall intern and welcome Andrew A.J. Coley, if he's here somewhere. We do the embarrassing stand thing, unfortunately for you. A.J.'s a 3L at the Catholic University of America, Columbus School of Law. He interned at the Commission's Enforcement Bureau at NENA and at SES Networks, so he brings some good practical experience to the floor, which we've been lacking. He says he enjoys hiking, biking, and I'm told relaxing with a new book. I'll have to take his word for it. I haven't seen any of this take place between 9 to 5 at the office. AJ's already proven to be an asset to our office during this extremely busy time at the commission, including by pitching in on the wireless infrastructure item. So thank you for your work and welcome aboard.
Congratulations to all those who are celebrating some of these announcements. Congratulations in particular to Commissioner O'Reilly on the arrival of Tess, and to Jessica Martinez. Quick vignette about Jessica. I realized that she was seriously dedicated to the craft of fantasy football when we were organizing our draft, and I hadn't heard from her a couple days. Our draft was coming up on a Monday, and she emailed me and said, "Oh, I'm sorry, I just had a baby 2 days ago." Wow, it's incredible. Not only that, she beat me this past weekend to top it all off. So congratulations to Jessica. And it's quite something to see. A few announcements in our office. We are also on the baby track. Rachel Bender returned to our office recently, having had Joshua a couple of months ago. She brought Joshua in recently. He is happy as a clam, cute as a button. We are very happy to have him as a member of the PI team, and congratulations to Rachel on that. Additionally, recently I started getting emails from somebody named Allison Stager. I didn't know who this was and why they were opining about various media issues. Then I realized, oh, Allison formally got her name changed in the email system. So Allison just got married a couple of weeks ago to the wonderful David Stager, who is a good friend of the office. Congratulations to Allison on that. Additionally, I want to commend the FCC staff that have participated in some of the Hurricane Florence-related events recently. In particular, I want to thank the unsung professionals who staff our operations center here at the FCC 24 hours a day, 7 days a week. A lot of folks might not even know we have an ops center, but they are really dedicated, and they're literally always at the phone, at the ready should something happen. And unfortunately, that did come to pass during Hurricane Florence. Folks who are in the ops center were specifically recognized by WWAY for their efforts in coordinating fuel delivery to broadcast stations, including that station, WECT, and WSFX when the storm first hit North Carolina. And having been privy to some of those communications, I can tell you that things were extremely touch and go for quite some time. So I personally want to thank by name Vion Cummings, Michael Evelyn, Jose Feliciano, Ron Levins, Jay Smith, Mark Stadnicki, and Haley Ramsauer. You stand as our first line of defense whenever emergencies strike. I also want to include a shout out to the FCC staff who were in North Carolina for a time: Paul Coburn, Lee Browning, Al Nur, and Johnny Lee. They conducted radio frequency scans before Hurricane Florence made landfall, and they and other staff have been helping during that time. Just a very quick and interesting anecdote from Lee, if I might, and he says, and I'm quoting here from his message, "At one point we were going south on Highway 11, headed towards Highway 74 in North Carolina, just west of Wilmington. We came to water on the road, which was rather moving fast and deep, so we turned around. There was a young couple in a large Ford pickup that passed us and started slowly entering the water. Paul and I decided we should stay just in case. He proceeded, and the truck was washed into the creek and started to sink. When I lost sight of the truck, the water was about a foot from the top of the truck, and the driver was on top as the truck floated downstream. Anyway, we lost sight of them, but could still hear them screaming for help. We looked at our location on the DF system, and Paul called it in to 911, and I was yelling back that we called it in and that help was on the way. Within a few minutes, a high water rescue team was there. We explained what happened, and they unloaded their boat and went in to get the stranded couple. It was fortunate that we were there because no one else was present when the truck was washed away, and the truck and couple could no longer be seen from the road. We just happened to be there when the truck with two people tried to drive across the washed out road, got stuck, and started floating away." This is what the FCC staff do each and every day during emergencies. And I want to thank those particular staffers, as well as all of the folks who are involved in our public safety efforts. You are the very best of this agency. Last but not least, I want to salute, even though she's not a part of this agency, Maureen Olhausen. She resigned her position recently at the Federal Trade Commission. Maureen served ably for many years as a staffer at the FTC, including the Office of Policy Planning. She then became a commissioner and ultimately served as its chair, acting chair, from January of 2017 until earlier this year. Maureen has a fabulous mind, a terrific model of leadership, and a huge list of policy accomplishments to her name. Wish her all the best in the time to come and enjoyed working with her and her successors at the Federal Trade Commission. If there are no other announcements, Madam Secretary, could you please announce the date of the next FCC agenda meeting?
The next agenda meeting of the Federal Communications Commission is Tuesday, October 23rd, 2018.
Until then, we stand adjourned.
All right, we're ready to get started with the post-open meeting press conferences, and there are a couple of familiar faces in the audience. So we're going to start off with the chairman's press conference, move to the bureau press conference, and then to those of the commissioners. And so I'll turn it over to the chairman, who will make some opening remarks, and happy to entertain some questions from you all. So Chairman, the floor is yours.
Thank you, Tina. First, I would like to thank Hank Hunt. You all know his story by now, of course, so I won't retell it. But what I would say is that I've had the privilege of working with Hank for roughly 5 years to get to this point. And from the first day I met him, I've been so impressed with his dedication, his courage, his persistence, and I'm proud that he could join us today as we honor his daughter and make sure that the tragic situation that Carrie faced back in 2013 doesn't happen again. An access code shouldn't stand between people who call 911 in need of help and emergency responders who can provide that help. And so thanks to Hank, among others, this glitch in our public safety system is being fixed, and I'm grateful for that. Next, I would like to thank the head of our Public Safety and Homeland Security Bureau, Lisa Folks, Chris Anderson, who leads the Bureau's Operations and Emergency Management Division, and Zenji Nakazawa, my public safety advisor. They traveled to North Carolina late last week to assess the communications and public safety situation following Hurricane Florence and to assure state and local leaders that the FCC is committed to helping in any way we can. In addition, I'd like to thank the North Carolina broadcasters and the others who have reached out and to whom we have reached out affirmatively for their feedback. The feedback on this historic storm had a familiar ring to it. As with previous emergencies, there were multiple accounts of people coming together and going the extra mile to help their neighbors in need. And as with previous emergencies, members of the communications sector helped lead the way. You had broadcasters sleeping on cots at the office 24/7 in order to stay on the air. Making sure that storm victims had access on the latest weather updates and information about where they could get help. The State Emergency Operations Center facilitated the rerouting of 911 calls from compromised call centers, and it appears that all 911 calls went through, which is a remarkable feat when you think about how much water was dumped in that region. Like Hank Hunt, these Americans are doing extraordinary things, and our communities are safer for their efforts. And so on behalf of the Federal Communications Commission, I would like to thank all of them for inspiring Americans with their service to the public during incredibly trying times. With that, I'd be happy to take your questions.
Matt, go ahead.
Hey?
Chairman, Matt Danner, Communications Daily. It's a bit of a multi-parter, so forgive me.
Okay.
Can you give any specifics on where media modernization efforts are going to go next following Form 325? What's next on your agenda for the next 3-6 months? Does the agency have any interest or thought of getting into retransmission consent issues? If so, when, how? If not, why not? That's my multi-part question.
Okay, so I guess in a nutshell, we have obviously teed up a number of different issues through our notices of proposed rulemaking in the Media Modernization Initiative over the past 20 months or so, 17 months. And so we'll be taking a look at the record that has been compiled in some of those notices of proposed rulemaking and trying to figure out what the appropriate way forward is. With respect to any other issues that might be teed up, or that we could tee up, I don't have anything in particular to report either with respect to substance or time frame, I'm afraid. But as you can tell from the tenor of the MMRI proceedings that we've had, we're always open to suggestions on ways to update our rules to reflect the marketplace that we have today, as opposed to the marketplace we might have had in 1992 or 1975 or 1934. Across the board, we want to make sure that the regulations match the modern marketplace, and that is the common thread linking all these things from Form 325 to keeping hard copies of the FCC's rules in broadcast stations.
Margaret?
Margaret McGill with Politico. What concerns, if any, do you have on the impact of the tariffs on 5G deployment?
Look, we're focused on what the FCC can do to promote 5G deployment. The primary barrier to recognizing the 5G future for American consumers and for American innovators is federal, state, and local regulations that impede 5G deployment. And that is why the FCC has taken aggressive action, including today, to make sure that those regulatory barriers do not stand in the way of consumers being able to enjoy next-generation wireless connectivity, innovators being able to set up shop here in the United States and develop 5G technologies. Ultimately, I think that is going to be one of the critical components for closing the digital divide, and I'm pleased that the FCC was able to take action today.
Hi, Chairman Pai. Kelsey Griffiths with Law 360. I was wondering if, just in light of some of the buzz surrounding the White House 5G meeting that's coming up later this week, maybe you could talk about what working with the White House on this issue might look like, if you have any thoughts about that yet.
Well, just stay tuned. You're going to find out in a couple of days. But overall, I think we're just focused on making sure that the United States maintains and extends its leadership in 5G. And for my part, I'm going to be discussing some of the FCC's initiatives, both with respect to spectrum and infrastructure. And I think today's decision is exemplary of the kind of efforts, proactive efforts we've had in promoting U.S. leadership in 5G.
John Reed, Bloomberg Law. Does the FCC plan to take any legal action against states that have passed net neutrality laws?
I can't comment on what strategy the FCC might pursue if and when states choose to take those decisions. I've outlined broadly the kind of framework we would use in that situation, but we'll have to wait until that hypothetical materializes.
You believe they're unlawful, right?
Again, I would refer you back to the speech I gave in Maine recently and then previously to discuss that framework that we would apply.
Howard Busker, Communications Daily. Yeah, I was also curious about the 5G report that the administration's doing, and I just wanted to ask one more time. So is there anything in particular that the FCC is looking for in terms of help from the rest of the administration and other ways that the rest of the administration could spur 5G deployment?
Well, I mean, we're obviously working with our federal partners with respect to, for example, spectrum. And so we have a close working relationship with NTIA over the Department of Commerce. We talk with other federal partners in terms of spectrum that could be usable for 5G. That's a cooperative process that is always ongoing, and I'm actively involved in that. On the infrastructure side as well, we're always looking for ways to collaborate with other agencies, including for example, NTIA and Department of Agriculture, anybody who is interested in trying to find ways to streamline the process to make sure that this necessary infrastructure, which does not exist at scale in the United States as of today, is able to scale rapidly. Because as Commissioner Carr aptly put it in his remarks, right now we don't have the scale necessary to achieve 5G deployment. And again, as I said in my statement, all the spectrum in the world won't matter if you don't have that infrastructure. And so we're willing and able to work with any federal partners who share our goal in closing the digital divide, and in this particular case, as it affects 5G deployment.
David, go ahead. Yeah, David Calc, Communications Daily. Some Lifeline advocates held a little rally out here this morning protesting what they see as your proposals to gut the program. Can you give us any update on your plans, timing, or substance? And particularly, are you having any second thoughts on the proposed ban on resellers? Because it doesn't seem there's any support for that. So.
Well, we are actively, not nice framing of the question. So we're actively studying the record and still taking meetings. In fact, just last week, I think it was, I had a meeting with some Lifeline providers to discuss the appropriate way forward. And so we don't have any decisions to report at this time, either with respect to substance or the process, by the time frame within which we'll make a decision.
I noticed you didn't make the meeting, by the way.
I'm sorry?
I noticed you didn't make the rally for some reason.
Oh, yeah.
Hi, I'm Tim Phelps. Chairman Pai, President Trump announced last month that the Iran sanctions have been officially cast and stated that, quote, anyone doing business with Iran will not be doing business with the United States. Yet on May 29th, you announced the successful transfer of the $1 billion local number portability administrator contract to Telcordia. As you know, Telcordia is a subsidiary of a company, Ericsson, which has done and continues to do considerable business in Iran, including work with an Iranian government-controlled entity. In light of U.S. sanctions and the fact that the LMPA has been described by members of Congress is vital to the nation's critical communications infrastructure, public safety, and virtually all significant criminal and national security investigations. Isn't the transition of the contract to Ericsson out of step with the president's policy?
The process by which the LNPA contract was awarded and ultimately the LNPA functions ultimately transitioned to the current contract holder was an extensive one. It included a great deal of vetting, both without and within this agency. And I'm confident that our administration of our involvement in that process was one that comports with the law. I would have to refer you to the Office of General Counsel for any particular questions about various legal provisions that might be relevant here. But overall, I'm quite confident that our decision was faithful to the law.
Thank you. Mike Macy at Governing Magazine. As you know, many local governments have entered into their own agreements with individual telecom providers. Can you talk about whether you expect those to be affected, and any guidance on how localities should pursue future partnerships with providers?
I would defer the particulars of the answer there to Commissioner Carr, who, after all, was leading this effort. I'll simply say, from a 60,000-foot level, our goal is to make sure that everyone, everywhere in this country, is able to benefit from 5G technologies. And that includes the constituents of localities which, for too long, have been on the wrong side of the digital divide. For example, there are many lower income areas in urban parts of this country that don't have the same digital opportunities, I call it, that folks in better off parts of that city might. And so we want to make sure that some of these local regulatory barriers don't stand as an impediment to those parts of the cities getting digital opportunity. More broadly, we want to make sure that we have a consistent set of regulations that every company, big or small, but especially the smaller ones, are able to abide by. We want to make sure that if there's a new wireless competitor, for example, they don't have to invent a wheel every single time they go to every single city across the United States. It is effectively a barrier to entry in and of itself that impedes the deployment of next generation wireless connectivity. And so we want to make sure that we have a reasonable, balanced, light touch approach to federal and state and local regulation that obviously preserves the public interest and promotes next generation connectivity.
Hi, Chairman. Casey Egan with S&P Global Market Intelligence. I know you can't comment on the particulars of any transactions, but do you believe in general that any separate or additional consideration needs to be given to prepaid markets when assessing wireless transactions?
That obviously involves one of the issues that has been teed up in a particular transaction that is before us, and so I can't really comment on whether we would consider it to be relevant to the transaction, or, assuming it is relevant, what determination we might make in the course of our consideration of that transaction. So I hate to punt on it, but it is obviously something that has been raised in that proceeding.
All right, you good? All right. Thanks,
Okay,
everyone.
happy fall.
At this point, we'll transition to the Bureau press conference with my colleague, Mark Wickfield. Take it away, Mark.
Okay, we'll just go through the various items. Are there any questions on Carrie's Law? Okay, if the public safety wants to come up.
Hi, Kelsey Griffiths with Law 360. I was wondering if you might be able to talk about some of the barriers to making this multi-line telephone system easier to access. What was the reason for the dialing 9 code, and what prevented that from happening before now?
Well, there's a lot of history to the evolution of multi-line telephone systems. It's described in a fair amount of detail in the notice of proposed rulemaking, so I don't really have anything to add to the details that are there. I think typically when you're dealing with these types of systems, if they are in campuses or buildings like this one, you're dealing with a number of different actors, many of whom are identified by the law. The manufacturers who actually build these systems, the companies that install them, and then parties that are responsible for actually operating the systems. So there are many variables, and also the technology that is used for multi-line telephones has evolved. In the olden days, we are talking about things like PBXs, really legacy telephone technology. But what we're seeing now is that these systems are typically IP-based systems. Much of the technology is in the cloud. So we're also dealing with a lot of technological evolution and really kind of a wholesale change in the industry. So all of those factors come into play, which is part of why it's so complicated.
Thanks, that's helpful.
Anything further on this one? Dave?
Were there any substantive changes to the draft?
There were a few non-substantive changes, so pretty much the version of the item that was released a few weeks ago is what you'll end up seeing in the final version. That hopefully will be released as quickly as possible.
Anything else? Okay, thanks. Thanks, Public Safety. Anything, questions for the task force on the CAF auction? Okay.
I will
Dave?
ask one on that.
Okay, all right.
Yeah, can you tell us, there's supposedly 190,000 subscribers that are being supported by this auction through satellite broadband. Can you tell us, are those people actually getting service now? Because you all say this is going to be 700,000 new people getting broadband. But Viasat, which as I understand, won the satellite broadband support. Can you tell us, are they actually already serving those people? And also there's a question about WISPs. First satellite broadband.
Yeah, so Viasat was one of the winners in the auction, and the areas that they won were eligible for the auction because they currently aren't served by terrestrial fixed broadband service at 10.1. And then what Viasat has to, their deployment obligations, milestones, may be different from their current offerings. They've committed to offering 25.3 and the usage allowances that go along with that baseline tier. In the auction, they have to offer rates that are reasonably comparable to rates in urban areas, and that's determined by the FCC's urban rate survey. And
But can you just say, are they already being served with some sort of broadband that meets at least 10.1 or 25.3?
I think I'd probably have to refer you to Viasat on what they currently report for that, but what they currently offer in those, if they serve those areas currently.
Thanks. Let's see, next is 5G. Questions on 5G? Yes. A wireless team, please.
Okay. Yeah, Howard Bresker, Communications Daily. I just was trying to clarify, and I don't know how much clarity you can shed on it, but there was some talk about some edits that Commissioner Rosenworcel in particular had gotten on the item. And can you give us any color in terms of any changes since the draft was circulated?
There's some changes here and there, and I'm not going to try to go through all of them, but the one that Commissioner Rosenworcel was talking about is actually one that was described in our presentation, which is that to accommodate the fact that some of the new shot clocks are shorter, if a city gets an application that's not complete, instead of pausing the shot clock and then picking it up again at the next day, As long as they notify the applicant within 10 days, then the clock goes back to 0 again. So that's what she was talking about. So that would be a substantive change since the first draft.
And other things were just basically smaller edits and not.
Yeah, I mean, there's some changes here or there, I would say. As a matter of substance, that's probably the biggest, the most significant thing.
Okay, thank you.
So if this goes through as planned, how far away are we from having a 5G network in this country?
I would not want to speculate, but it is clearly the case that a number of carriers have announced plans for commercial deployments that are beginning before the end of this year.
Anything further here? Okay, thank you.
Thank you.
The next item would be the 2 Enforcement Bureau items. Any questions on those? Okay. Media Bureau, media rule modernization, questions on that item? Okay, and then the toll-free auction item, questions on that one? Okay, and finally, the eSIMs, International Bureau. Okay, all right. IB?
Matt Daneman, Communications Daily.
There's so many.
Since the draft, there had been a lot of ex parte discussions about things such as NGSO eSIM rules, about sort of carve out for aeronautical eSIM. I'm wondering what was approved today. How does it differ in draft from the draft form, particularly with those issues that have been ex parte a lot about?
There's no substantive changes. We might make some of, incorporated some of the ex partes themselves and cited where we address those issues in the item, but that's it. I mean, there's no.
But nothing of substance?
No.
Thank you.
Okay. Anything further? Okay, thanks. All right, I think the commissioners are now here for their press conference, so thanks a lot.
Howdy, howdy. If it's all the same, why don't I let Commissioner Carr go forward, since he's been leading point on the wireless infrastructure for people who may have a question on that. Is that fair? Okay, we'll start there.
Thanks. Very glad to get the votes across the finish line and put these reforms in place. I think as the statement laid out, we think this is really going to be key to helping win this race and really do it in a way that's going to benefit every community in the country. So happy to take any questions that you have on it.
Okay, I have a question that's kind of related to that,
Okay.
for both of you, hopefully. Commissioner Rosenworcel talked about tariffs and has talked about tariffs a couple of times lately. And the statement CTA put out said basically, we're really happy that the FCC did this, but it doesn't obviate the fact that we're very concerned about the tariffs and that the effect on 5G deployment. And I wanted to ask both of you, the extent of concerns you have that this could potentially slow down deployment.
Well, I defer to the trade experts when it comes to these issues of international relations and trade policy. So I don't express a view on that. But what I will say is, to the extent the concern that's motivating this is about unnecessary costs being added to the deployment of 5G. Well, we all had an opportunity right here to strike a lot of those costs. So this one decision, again, it's $8,000 per small cell that right now is being added with unnecessary government fees. So again, if the concern is about, that's roughly 25% maybe of the cost of a small cell. If you're concerned about unnecessary 25% cost added to a good, right here we had the chance, within our jurisdiction and expertise, to vote to remove that, and we did. Should I try that again?
No. I was hoping, I wanted to see if Commissioner Riley had anything on the tariffs.
Look, in a previous life, not too long ago, I was one of those that was very engaged in trade matters and spent a ton of time on trade policy. Coming here, I have not spent any time on trade beyond the issues that you're well aware of, but I have not spent any time on the tariffs and haven't looked at the details, so I don't have any more insight to provide on that aspect. To the extent in my old hat that this entire effort is about, addressing unbalances and unfair practices by other nations on trade matters, I think that's incredibly valuable, but I think that's the best I can say right at this moment.
Hi, Commissioner Carr. I had a question for you about the 5G order. What assurances have you received that the funds that are saved on the small cell siting fees will go directly into deployment?
Yeah, a couple. One, the economic analysis that's in the record shows that by cutting this $2 billion in costs, that's going to incentivize $2.4 billion in investment. So this isn't a situation of cutting regulatory costs that are then pocketed. The analysis shows you're getting more investment than you are seeing in costs. 97% of that is going to be in rural and suburban communities. Second, we've heard from the local officials that are on the ground that are working to get 4G and 5G deployed in their communities. And their position in the record is, if you address the exorbitant fees in some big must-serve cities, that's going to make a difference in getting broadband to our communities. And third, if you look at the decision we adopted, it walks through in detail specific examples of where high fees in certain jurisdictions and lower fees in other jurisdictions have impacted deployment. So I'm very confident by taking this step, we're going to free up more investment for deploying more broadband.
As a follow-up to that, have you received assurances from carriers themselves that this is the type of effect that it will have for their business models?
Well, I'd say we've seen it in all of those pieces of evidence that I just walked through. More broadly, this comes down to a regulatory philosophy approach. Who's best situated for sort of deciding and dictating exactly where, sort of a census block by census block, where deployments are going to go? Is it the private sector and the free market, or is it us sitting here? And if you look across the board at our regulatory decisions, licensing and otherwise, we don't impose or micromanage build out in that respect. We do have build out obligations at a high level on our spectrum licenses, and those are going to continue to apply.
Thank you.
And I feel like I'd be derelict if I didn't ask, because you were talking about the 8,000 per small cell. Isn't it hard, though, to quantify those kinds of savings? I mean, it seems like
No,
just in
8,000
terms-
is easy to quantify. It's $8,000.
No. What I'm saying is how you do the calculations and come up, I just don't know.
Well, thank you for everybody giving my history with math. I was not the one that came up with those calculations. But if you look through, these are economists that looked at the
Right.
decision, looked at the math. They filed a lengthy document on that, and that sort of walks through how they reached their decisions.
Yeah, I was just saying from an economic, it just seems like the economic analysis on that would be hard to do that analysis with very much certainty. I guess that would be my concern. But
Hard for me to do it, but economists do it pretty well.
okay. I'm not an economist.
I don't mean either.
So in regards to bridging the digital divide, can you talk about whether you would pursue build-out requirements in some form in the future, or if you feel that it's best not to pursue such federal mandates?
I'm pretty serious about build-out obligations. Right now, we do have federal build-out obligations that apply to spectrum licenses. They vary depending on the license. Sometimes it's 75% or 80% of a geography or a population, for instance. I think you've seen the record of this commission taking very seriously build-out obligations and not extending build-out obligations or doing so isn't consistent with our precedent. I'm always open to a conversation about whether we need to take a fresh look at build-out obligations.
We reached that point. Is there any other questions?
Yeah, can I ask a CBRS question?
We almost made it. Sure.
You knew we couldn't let you off the hook that easily. I just wanted to, we had heard that there were some problems with this and that Iraq was looking at parts of it. And I'm just wondering if there are any concerns about could any of that hold up, progress toward a final FCC order on the 3.5 gigahertz rules?
Well, in terms of any changes that we were contemplating. Of course, the timing of all that is determined by the chairman, not me. I think as I've indicated, I think we're getting really close to imminent to being decisions on and ready for action on the final remaining pieces that we contemplated in the item. None of the debates that I've heard so far throw me or suggested that we're not sufficiently ready to move forward in the near future.
And the questions about the ESC and sensing, that shouldn't hold up the work that you're doing, right? I mean,
That's right.
It's kind of
right.
related, right?
The SASs and the ESCs are going to be needed, whether it's on the PAL side or on the GAA side, and hopefully that will be resolved. And I've been working to facilitate some of that for many months now, and hopefully we'll conclude that. But that runs parallel to the work we need to address in terms of the changes potentially on the PAL side that the Commission may consider in the near future.
And are there any new developments on 5.9? Because I think once 3.5 gets taken care of, that's going to be a band that's going to get probably the next focus.
Yeah, I think there are, I don't want to say new developments, there are a lot of different interests in trying to address that issue, and I don't know what we may do in the very near future, but I think there's conversations continue.
Thank you.
Of course. Well,
Commissioner O'Reilly.
Of course.
Matt Danneman, ComDaily.
Yep.
In the Form 325 item, you had mentioned how there's a number of other items that have been briefed and ready to be teed up. Can you give any kind of guesstimation as we're looking at the next 2-3 meetings? What sorts of things are going to be primary?
Well, that's on the media modernization sector. We've done about a dozen, I think,
right.
and most of them are done. There are a couple of them that aren't full. KidVid's and still getting comments.
I guess I was wondering if you can handicap and give a sense of these are probably the 2 or 3.
Again, those are the chairman's discretion, not mine. I am hopeful and that we will act on all of those. They're relatively small scale. They're important issues, but they're small scale, as you saw the one today. Beneficial, but not earth-shattering. And so I think we can move forward on the 8 or so that are remaining. And then what I'm looking forward to is okay, what's the next round? And the next round, how do we keep adding? Because there are, the burdens on broadcast and cable industry is incredibly thick, and they no longer make any sense if you read my statement from yesterday or 2 days ago on the 621 conversation. So I think that our rules are due, and a number of them can go. Many of them are in what I would consider in the small, medium category, not the earth-shattering Tier 1 segment. So I would like to add to our portfolio while at the same time addressing the 8 or so that remain. But the roundabout way of saying, I apologize, but the timing on any topic is to the chairman, and I don't get ahead of him on that, and try and keep it as good grace. All right, any other questions before I head to lunch? John Donnelly, John Donnelly, okay, all right. Thank you all.
Thank you.
Thanks, guys.
All right, we'll see if I get any more robocalls on these two things while we chat.
Hi, Commissioner.
Sure.
I wanted to ask a question about, you mentioning VDAC and some other maybe task force-related work that could help address some of the concerns on the local level with the 5G order. I'm curious because it seems like the FCC's line has to come down somewhere. So from a regulatory perspective, how do you think this order could have been better, other than encouraging more collaboration and that kind of thing?
That's a fair comment. I think it's worth noting that with respect to the shot clocks, I did vote to approve when my colleagues agreed to my changes. Our existing shot clocks for wireless service are 120 and 150 days. They were designed for an era of macro towers. As we move to this new era of small cells, it's legitimate to consider changes, and we did make changes here. We shortened them. But I said it was an imperative that we do 2 things. First, we give municipalities some time to adjust to those changes. And second, that we make sure that when material is filed, it is complete. I think those 2 changes reflected a pretty good balance between federal authority and local interests. I just did not find that that existed in other areas of the order.
And Commissioner, this is Howard Busker, Communications Daily. Did you voted to approve, not concur on those?
I approved in part and dissented in part, yes.
Okay, okay. All right. And let me ask you the tariff question, because I know you've raised this issue, but CTA's statement almost seemed to make it sound like they were glad for what they think is going to be some gains made on 5G in this area, but how much of that is going to be counteracted by, by problems caused by these rising tariffs. So, I mean, what do you think of what's your thought? What are your thoughts on that?
I think they're right. There's a $2 billion figure that's been floated around, and that represents only 1% of the cost of our deployment for 5G. That's really small. But here's what we know. We're going to have a 25% increase by the end of this year on essential antennas, routers, switches, and circuit boards that are all necessary for 5G deployment. Well, so much of our discussion here today was about theoretical costs and speculative costs. We know with extraordinary clarity that by the end of this year, we will have a 25% duty on some of the most critical equipment for 5G networks. That's not going to help us lead. It's not going to help us be first to the future. And I do not think it's acceptable for this commission that is so concerned about the cost of network deployment to be silent on this subject.
John Reed, Bloomberg Law. On the tariffs, are there any actions that the FCC could take to sort of counter the effects of the tariffs that you're aware of?
Well, I'm a minority commissioner
But just conceivably.
on a team of 4 right now. So my primary tool is speaking up, and I hope my colleagues will decide to do so too. I don't think their silence, if they care about this issue, is acceptable.
Also on 5G, there's supposed to be a White House event on Friday, but I understand that you were not invited to that. Do you have any thoughts on that?
I was not invited.
I mean, would you be willing to offer your advice if they ask you for it?
I'm willing to sit down with anyone, anywhere, no matter what side of the aisle they're on, to try to work with them to make good policy and make our communications network strong. That's always been the case, and it always will be the case. That it?
Okay, so I'll ask you about CBRS 2 and 3.5, because there's been,
Yeah.
We're hearing that there's potentially parts of it have run into some problems in Iraq, and not the country Iraq, but the,
Yeah.
right?
I'm enough of a spectrum nerd to know
Right,
exactly
it
what you're
sounds
talking
right.
about.
It sounds more interesting
Yes.
with the country Iraq, but not the case. I'm just wondering if are you hearing anything along those lines? And do you see any concerns that potentially the rollout of 3.5 could be slowed at this point? It's already been
I
pretty
think
slow.
the rollout of 3.5 has already been slowed. We have a serious deficit of mid-band spectrum in the United States. South Korea, Italy, the United Kingdom, Spain have already set out mid-band spectrum for auction. China's already cleared airwaves as well. But somehow we are sitting here many years after our initial proposal in 3.5 gigahertz band, and we're stuck in some kind of bureaucratic quagmire I do not understand. We should have moved ahead a long time ago. I don't have any insight, but I am exasperated. We should have done this a long time ago.
Thank you.
All right, lunch.
Thank you.
That's later.